Good morning, everyone. I'll call the meeting, the November 25th, 2019 meeting of the Deschutes County Board of Commissioners to order. Will you please join us in the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Well, welcome everyone, and happy Thanksgiving, all of you. This will be our only meeting this week, so we've got kind of a variety agenda with some action items. The first thing we do in the meeting is a citizen input, and if you want to give citizen input on anything that's not on the agenda, you need to fill out a blue form and give it to Laura here. I've got two requests currently for citizen input. First is Tom McManus, and then second is Mike Stowe. And if it looks like you're both talking about the same issue, if you want to come up together, you can and sit at a table. And there's 3 minutes time to say your piece on for each of you. Thank you.
It won't take that long, Phil.
What's that?
It won't take that long.
Okay.
Good morning.
Morning.
I'm ready. My name is Tom McManus. I am chairman of the Fall River Estates HOA. I've been here before and before the board before on this particular issue that has to do with our special road district. I'm here today to ask the board not to nominate or approve any nominations for any new officers to the SRD. We have an opening coming up in December. The reason why I'm asking for that now is so that that person who is nominated isn't tainted by the prior actions of the SRD board. I believe you know that we've made some complaints to legal authorities about the activities of this SRD board. In fact, I've sent by email copies of those complaints to you. Those complaints are with the sheriff's office, with the district attorney's office, and with the Oregon Ethics Board. These are serious violations of misuse of public funds, of ethical violations, which are repeated in many, and a continuing disrespect for the members of our community by never agreeing to discuss and try to get these things resolved amicably and to the benefit of the membership. So that's why I'm asking the board today just to hold off on any future approvals and nominations until these ethics complaints and legal investigations are complete. Thank you.
That was simple and fast.
I
Get
told
the
you.
rest of your time?
Yeah, I don't know.
Okay.
Keep on
My name is Mike Stowe. I live in the Fall River Estates, and presently I am a member of the ad hoc committee that was formed for the purpose of trying to get the situation between the HOA and the SRD to calm down and get resolved. However, every attempt that I have made with the SRD current membership, board chairman Bill Swanson, has met with total ignorance and avoidance. We have a complaint about the money that was spent in the road district inappropriately, and what we believe was illegal. We've tried to bring this attention before the SRD board, and they won't talk to us about it. All they do is continue to say, "Oh, well, I did it this way, I did this way, and this is why I did it this way, da." But absolutely will not allow us to bring to the board's attention the total illegality of what they've done, or what he has done. The other problem is also that this current board continues to break the Oregon Public Meetings Law. They have secret meetings, they make decisions at their secret meetings, and then they just come to their SRD board meeting and rubber stamps their decision without any discussion. So we're faced as members of our community with a problem, a very serious problem. It's very divisive to our community. It has caused some members of the friends of the SRD to personally attack other members of the community because we don't agree with them. And it's getting out of hand. There's been stalking orders issued and all this kind of stuff. What we're doing is just asking you to please hear us, hear our problem, because it's very difficult to get any resolution other than taking it to circuit court and suing them.
Was the buzzer that went off the second 3 minutes
For the first.
or the first 3 minutes?
The first one. I'm sorry if I
It
bore you,
didn't
but.
get
No, you don't bore me. I'm just trying to,
Get restarted.
okay, yeah, so I'm just trying
Well,
to keep track of our time.
I'm done.
You're good. You got a little more time, I think, actually.
Please,
If I-
listen to us.
If I can, I want to reintroduce two other members of our ad hoc committee. We have Terry Douglas, who's a member, and Dr. Lyle Nelson is here, who are also part, and we have other members that are part of that ad hoc committee that we formed of the SRD membership to try to resolve this.
Well,
It's a
thank-
battle. It's a
yeah, Thank
very
you for
serious
coming
battle.
in today and kind of bringing us up to speed. This has been an unusual situation for us with the road district and the homeowners and the conflict. And, as last year, we tried to solve it by election, and I don't know that it solved much, but we'll take it under advisement. Comments?
Thank you for coming in today and
Yeah.
giving
Thank
us
you.
the
Yeah, thank you.
information ahead of time of your actual election coming up.
We'll probably discuss it a little bit with legal counsel about further steps, so,
Fantastic. Thank you very
thank
much.
you.
Paul.
Thank you. Thank you,
Just a
Tom.
quick statement. So this is an impedance mismatch from an engineering term. I mean, you can go create legal documentation, sue people to high heaven on this. This is a small community. This was a volunteers working in a road district, homeowners association, people moving in and out. I mean, you've got to figure this out in your community. You're just going to drive everybody crazy. You're asking the Board of Commissioners to rule on something that's not in our domain. You're asking the Sheriff's Office to, I don't know, come up with charges or investigate something, which isn't a big issue there. You're trying to put ethics charges. I mean, this is kind of silly at some point, because I've been in this situation at the Park District back in the day 15 years ago. It's not valuable for anybody to take this to court and to try to have fingers pointed back and forth. You've got to work this out in your community, down the street, neighbors and friends. And if you're not going to be friends, just figure out how the relationship's going to happen. Thanks for letting me share.
Any further comments?
We can talk afterwards.
Yeah, thank you. Any other citizen input on any other issues that aren't on the agenda? Okay, so we'll move on to our consent agenda. Looks like we're going to pull items 1, 2, 3, and 4. 5 has been moved to another date, so I'd seek a motion for approval of 6 and 7, and then we'll start in with the others.
I move we have approval of consent agenda items number 6 and 7.
Second?
Okay, further discussion? Commissioner Dare?
Yes.
Commissioner DeBonne? Yes. The chair votes yes. So we're going to go back and we're going to have to do items 1 and 3 this afternoon at our 1:30 meeting. So we'll start with item number 2, the consideration of board signature of document number 2019-772, the services contract with David Evans. We're joined by Cody Smith, our county engineer.
Good morning, Cody Smith, Road Department. So before you this morning is a services contract with David Evans and Associates for engineering services for the Northeast Negus Way and Northeast 17th Street Improvement Project. Road Department had issued a request for proposals back this summer. We received 3 proposals, 3 different engineering firms. After scoring those proposals based on the scoring criteria that was in the RFP, the top-ranked firm was determined to be David Evans and Associates. We've negotiated the terms of the contract with David Evans and Associates over the past few months. A little bit of a delay in bringing this before the board because coupled with that, we've also become aware of a partnership opportunity ultimately with Central Oregon Irrigation District with the piping of the Pilot Butte Canal, which runs across 17th Street. And so a component of our project was actually removing the canal crossing bridge on 17th Street, which is in poor condition currently, but with this partnership opportunity that became clear to us, we've kind of held back a little bit and wanted to make sure we had coordinated with COID a little bit before we entered into this contract for our design services for our project. So, yeah, with that, so before you, maybe a little bit about the scope of the project. So, Northeast Negus Way and 17th Street are contiguous with one another, connect the northeast end of Redmond to O'Neill Highway, also provides access to the Negus Transfer Station. The improvement of this road is identified in the county's transportation system plan. On top of that, this piece of road, the pavement condition of this road's been getting worse and worse over the years. We've kind of been putting off doing any kind of pavement preservation, knowing that we were going to have an improvement project that was identified in our TSB for this road. Project was identified in our 5-year capital improvement plan, in our fiscal year 20 CIP budget. So with all that before you is the contract with David Evans and Associates to provide the design services for the project.
Okay. I had a question. On your page 36 of 42, our packet page 79, Cody, there isn't a signature for the risk management review. It's not, my copy isn't signed or dated.
Okay.
And-
So actually, the original contract is setting, so subject to your guys' review. This would go to legal counsel for their signature and review as well, in addition to risk management.
Okay. And
Legal's
then,
seen it already, I don't know about risk.
Okay.
and then my other question, and maybe, Dave, you'll tell me, but according to the contract, we were supposed to have, for the commercial general liability, $2 million for each occurrence and $5 million for the aggregate, according to page 35 of 42, from a single incident. And so if you go to page 86 of our packet, it shows for commercial general, it shows $1 million and $2 million general aggregate. So I'm just wondering, I know last time I brought that question up, you tried to tell me that there's another binder in here that's going to make sure that we're covered. But I just
believe
want
that's
to,
the case on this one. That would be something Risk would assess. Risk
Okay.
reviews the certificate of insurance and signs off on the insurance. And so I don't know if the original that is here has gone to Risk yet or not. It doesn't always get to Risk before the meetings. But if it has gone to Risk, we can certainly bring that to their attention, that the limits on the certificate don't match the limits
in
in
the,
the contract.
Yeah, and we can, that's not going to be an issue with getting that updated. The other thing is the insurance certificate that was provided expires next week, so they're already going to have to provide a new insurance certificate. So that's something that can very easily be addressed today by getting a new insurance certificate from them.
That's not uncommon in a lot of our contracts. There'll be expirations that are actually before the contract begins or maybe shortly after it begins. And Risk does monitor that to make sure those certificates match. So on this one, I can't speak. I don't know. Can you tell if Risk has seen it yet? Risk
Okay.
hasn't seen it yet.
okay, so I just want to make sure the dollars are correct. I don't want to issue. So, okay. Those were my questions.
Well, it looks like they would get one that would match that. Isn't that correct?
Correct. Yeah, those limits would have to be there and the coverage period before Risk will sign off.
They can buy that. Okay.
Okay.
So, other questions?
No, those were just my,
Mr. DeBonne, any
This
questions?
this is the contract to bring the project to 100% design, and then there'll be follow-on contract for implementing.
That's correct.
Yeah.
For construction, yes.
Yep.
so you're actually projecting the contract, or the project itself is going to be 2.5 million almost? But this is like 19% of that?
Yeah, so the total, right now in our CIP, we had this estimated, and that was based on the price that was shown in the TSP, which was from almost 7 years ago, at 2.3 million. With our current scoping, we're close to 2.5 million. Yes, this is just for the design of that.
it looks to me, Commissioner Dare, that the 446 of this contract is part of the 2.4 million. So
That is correct.
like you
Right,
said,
it's
roughly
19%.
19%, yeah.
That is correct.
Okay.
So that's kind of what I want to ask about. I'm always interested in the cost of things, and I was thinking about this. What would this cost if we weren't, we're a fairly prosperous county, and we have a fairly substantial amount of road funds right now, but I look at this as almost $500,000 just to design it, so that should buy us 3 employees for a year to design these improvements. I mean, I don't know what they pay at the engineering firm, but I mean, say they all get 100,000 plus and benefits. So that just seems like a huge amount of money to design this. Now, I know it's complicated, there's various parts to it, but was that a factor in the scoring, or is the scoring based on other things?
The scoring is not and cannot be based on price. So when then that's by state law. So when we're soliciting for architectural, engineering, and related services, we can't base that in the traditional contracting sense for those services. We can't base that scoring on budget. So the scoring is based on other considerations, such as the composition of the design team. So David Evans is the prime here. They have other consultants that'll be sub-consultants as part of their design team, delivering surveying services, delivering geotech engineering services, right-of-way services, other services such as that. With your example of us hiring 2 or 3 new employees, no, we still wouldn't have the capacity to deliver.
Not us, the David Evans is, yeah, so I'm just saying that it's like we're giving them almost $500,000. They should be able to hire 2 or 3 people. Now, I get that there's subs, so it's not that many, but I'm just saying, that seems like a tremendous amount of work, I mean, for this. But, I mean, it's like you start Monday, January, whatever, and you go till the end of the year designing this, and I just wonder if we weren't a prosperous company, what we'd be willing to pay, or county, what we'd be willing to pay for this, because it just, 20% design is, and I don't know if that's typical either. I mean,
I would say on an improvement project such as this, and this one has a little more complexity because we've got a canal crossing, structures tied into it. We've got the geotech component because of the new road section that we're going to have to build due to the current condition of the road. I would say anywhere from 15 to 25% would certainly be within reason. Obviously, the more complexity you add to a project, the higher up that goes. But 20% for preliminary engineering is certainly not out of reason.
interesting.
So do you think the 2.5 is really going to be adequate then, if you're saying that because of those new standards? Or is this, when we actually go out to bid for it, is it going to go up to 2.8 or 3?
Today, I would tell you that what we've scoped it at is what we think it's going to cost, at the 2.4 million.
But you said that was from
If we were anticipating the price would go up, then we would be adjusting that in our budget and in our CIP. So we haven't made that adjustment yet. So no, we don't anticipate that's going to go up.
Is this what you kind of anticipate the design to be too?
Yes. Yeah, we had estimated the design actually right at 20%, so we're just a little bit under that. I'd point out too that the original budget that we received was actually closer to 700,000. We negotiated with this firm down to the price we have now. So
That'd be
Good job.
4 or 5 people that work for a year on it. Okay. All right. Any other questions? Seek a motion to support this.
I'll move board signature of document number 2019-772, service contract with David Evans and Associates for the Northeast Negus Way and Northeast 17th Street Improvement Project.
I'll second it with the assumption that we're going to have risk being part of this.
I'll
and
agree with that.
Updating the insurance requirements.
I
Agreed.
thought you were going to come in as long as we get for 2.4 million.
Well, that too.
All right. Any other comments? Commissioner DeBonne?
Yes.
Commissioner Dare?
Yes.
Chair votes yes. Thanks for the explanations.
Okay,
Thank you, Cody.
thank you.
Be interesting, maybe, I think in the past you have given us the kind of the scoring sheets. That's always interesting to look at. Does it
The scoring sheet was provided with,
was? I couldn't,
Well, it's just the numbers, the totals, some of
just the
that.
totals. I don't,
yeah.
I didn't
there
see the
isn't-
scoring sheet.
it's just the,
So if you're talking about the actual sheet with the individual panel member scores and comments, with that, again, by state law, we usually don't release those to the public until after a contract's been awarded, again, by ORS 279C and the procurement process for consultant selection. That information, as well as the proposals that are submitted, we don't release those for public inspection until after a contract's awarded.
okay, good, thanks. We're going to move on to item number 4, which is the consideration board signature document 2019-807 Criminal Justice Commission Illegal Marijuana Market Enforcement Grant. I think Joe's going to, yeah, and whoever's going to come on up and introduce yourselves to the, and I think we're interested probably in hearing just about it, and I remember we approved the application for this, so tell the details and kind of how you plan to spend the money. Good.
Morning, Commissioners, and Mr. Doyle and Mr. Anderson. I'm Captain Darren McMaster from the Sheriff's Office, and with me are team members from the Marijuana Enforcement Team. Kathleen Coop is back there still in the gallery.
We can get another seat. No,
There you go. She's coming up now.
good. All right. Thanks for joining us this morning.
Did you want introductions from everybody, or?
Maybe as you speak would be fine. I mean, we know most of you, I think, is pretty well, so.
So as you know, last year, the Criminal Justice Commission awarded Deschutes County a grant to do illegal marijuana market enforcement. And so we used some of those funds to enhance our investigations. And so that was only a one-year grant. We went out this past summer again to renew that grant for a 2-year period. For whatever reason, Criminal Justice Commission is off by a few months as far as everybody else in their budgets. But here we are this morning. We were awarded the grant. And what we're hoping for with this grant for the next 2 years is some enhancements in our investigations. We are looking to add a financial analyst on a contract to be able to identify and work with the numbers on the financial piece of the illegal marijuana market, because we've discovered that that is a big piece that we don't have expertise in, and we'll need a little bit of help with that. It continues to fund several positions, such as our in-house analyst. It'll also continue to fund the 2 researchers that we used in the past that produced that fabulous report that everybody here was able to see. So this total grant is for $436,000, $896, and don't forget the 92 cents. So,
Couldn't forget those.
yeah. So it's a really good perk for Deschutes County and the efforts to combat illegal marijuana in Deschutes County. And so I don't know if you want to hear what the breakdown is as far as what that money is designated for. I will go ahead and do that if you want to.
Sure, yeah,
Okay.
give us an oversight.
So I'll just round the numbers a little bit. 241,000 goes to personnel salaries. The contractual consultant services is 105,000. The space that we have $37,000 or so to go toward rent and utilities. $20,000 for training and conferences, which will help enhance our detectives' abilities to detect crime and to investigate those crimes. $20,000 in equipment. And then we have $13,000 in other expenses, which Kathleen, I think we're going to use that for the web page, right?
Some of that's in the contractual,
Yeah,
and then
right.
there's other things for printing
Okay.
and education materials.
One of the things that we're hoping to do different this year is develop a web page where the community can go to that web page, and number one, they can get factual information on what's illegal and what's not illegal. Hoping to, again, focus our detectives' time on investigating actual crimes and not going out and learning that it's, illegal marijuana grow for medical purposes or whatever it happens to be. And so we're hoping to focus our efforts that way. The webpage will also be a place where the community can go to and offer tips for our detectives to follow up on and look into. And so, do you want to add anything?
No, if you have questions, that's.
Well, one I have is, so I know that we had a fairly, a lot of results in the first year of doing the program with the detectives and your investigations and things. Do you see that continuing at the same pace or increasing? Have you, from what you've learned and what you expect out?
Yeah, I definitely see that the work is still there. I think there's a lot of different avenues that we can take the position and what we're doing with it. So, one thing when you do a search warrant on a place and then you find bank accounts or information there that might want to lead you into a financial investigation, that has been kind of a challenge for me, and dissecting some of those documents. I mean, I have one case right now where a guy has 10 different bank accounts, and those are hard to identify, and then trying to match those up with illegal sales has been a challenge for me and very time consuming. So depending on where we want to go with this, if it's all about hitting search warrants and getting numbers of plants, we can do that. I think that's in my personal opinion is not necessarily going to solve the issue, because the way that the criminal laws are written, typically people get probation, and we're just cutting down their harvest for a year. But if you go after assets, now you're actually hitting them where it hurts, where they probably can't recoup some of the cost to come up with another illegal operation. So
You need a forensic accountant.
yes, that's what part of this contractual consultants and services that they would be able to go through. I mean, I can tell you one case alone. I dissected one bank account, there was 4 bank accounts and with one person, and that probably took me close to a week to kind of match up the funds, and then we had some new program come in that we were able to use through the DOJ, Department of Justice, and they gave me information in about a half an hour of what I did in a week. So it really was beneficial to have that for our services there. So I think the work is still there. I definitely think that we're moving and we're making progress. If we look at the stats from, I think it was January 2017, we had 1,800 medical marijuana grow sites in Deschutes County. And as of July of 2019, we have 517. So I think our enforcement efforts are definitely pushing some of these people out. And as you could see probably in the news, when I executed 5 search warrants out in Crook County, every single person out there was a resident of Deschutes County. So my theory is that some of these people are definitely being pushed out into some more rural areas, but yeah, it's
Still keeping their ties to the Deschutes County.
absolutely, and everyone out there is going to be coming to Bend for their supplies, their fertilizers, their growing. Yeah, so it's all connected, and the community of Alfalfa has been very much begging me to do some work out there as well.
And if we added a second detective,
Yes, and I just got word from the patrol commander late last week that he can move over and start working December 1st.
okay.
And
Right.
Commissioner, if I could just add, you said there were,
You want to give your name for the?
Joe Brundage, I'm the business manager of Deschutes County Sheriff's Office. When you said the results last year, this grant is one of the results of the success last year. And we were told that one of the main reasons, we were awarded $436,000 versus I think $122,000 last year, was they saw the commitment we had to those positions and that we were doing this and we were committed to it regardless of if we got this extra money. So I see the $436,000 as a return on the investment the county made in those 2 positions last year.
Great. You want to add anything else, Joe? Or?
That's it.
So you're going to tell us about the cases, Mary.
Thank you, Commissioner Henderson. What I'm most excited about is the breadth of this grant and the involvement of all the different agencies and community partners. Last year, we were able to identify where we had gaps. The analyst was one of them. We do need someone with a strong financial background. We know that a lot of the county's resources are being exploited without any, lawful return taxes or anything of that nature. And we know the impact it has on the rest of the nation with the illegal marijuana leaving our county. So I think that we have been put in a position where we're going to be able to have a dramatic impact instead of just working on low-level search warrants where we're looking at felonies with probation. We are trying to step up and identify the bigger problem. So we have assigned a very experienced deputy DA who's a relatively new hire to the office but has a strong federal and state background. His federal background was in illegal drug prosecution, and he brings a wealth of knowledge, and he'll be working with the team on a regular basis. And we also have implemented quarterly meetings to make sure all the agencies are in agreement about what our priorities are. And with the addition of the financial analyst and the work of the analyst who I think is doing a fabulous job, I think what you'll see is maybe not the number of cases, but the type of cases that we're bringing will be cases that make an impact not just on that particular offender, but on the community as well, by removing some of those large-scale operations from the community. And that's really the goal, and the focus is to address the problem, and not plant by plant, but on a large scale, removing some of those offenders that are bringing organized crime to the county.
Can you give any kind of overview of the prosecutions that you have currently? Is there, I mean, we read about kind of the busts or some of the searches in the paper, but we don't really know what happens with some of them. So is there anything that's...
Yeah, I can tell you there's two aspects to it. There's the criminal prosecution. Those are moving forward. It's slow. I mean, as you know, we're dealing with some backlog given the current staffing at the court. We have the same issue at our office. But really, it's just hard to get those cases through because there's a limited amount of court resources. So those are solid, what I would refer to as a solid case, well investigated, able to go forward. We're going to meet our standard of proof. We feel confident in those cases. And then you have the forfeiture piece as well. And I would leave that to others to talk about the forfeiture because our office does not do that work. But I think it's that component of looking at both the criminal prosecution and the forfeiture that makes a difference.
Yeah. Any questions for Mary? Yeah.
Oh, thank you.
Good. Anything else you want to add, or?
I was just pleased that what they did with the number, the fact that it's almost $500,000, that for some of the awards that came out of, like the family drug court was really cut, but this number is significantly larger. So thank you for all your good work.
I think that has to do mostly with the team, the law enforcement team that's been working on this, and the work done by the researchers, because we have well-documented efforts and it's evidence-based, and that makes a difference.
Yeah.
Right.
Morning.
Morning. I'm Jason Maniscalco. I'm a lieutenant with the code team. So we work hand in hand with the illegal marijuana enforcement team. I guess what I would say is this has provided a great partnership between the DA's office, the Deschutes County, and Bend PD, and they've done a lot of good work. I've been obviously there firsthand to witness. It was kind of an educational thing at the beginning where they were educating me, but they were learning this is a complex issue. This is marijuana enforcement's with the laws are very complex. That team has done a great job, and they are driven. So I'm proud of what they've done, for sure.
Okay, thank you. And are you still housed with the code team, or are we at the sheriff's office now? Okay, so good.
Commissioner
Yes.
Henderson, they're still housed with the code team. The Deschutes County Sheriff's Office detectives are separate from the code team, but they all work out of the same building, the same office space, so that they can share information and interact. So,
All right, well, thank you.
Hi, I'm Kathleen Meehan Coop, and I'm with the District Attorney's Office, and I'll be handling the outreach and education piece, so the development of the website for the community, as well as reaching out to businesses that may be able to provide leads and educating them on what kind of information they should be sharing with the detectives, and when they might have leads to folks to be able to provide.
Questions, comments?
Congratulations on the grant. You know, it shows a commitment from the state legislature, also Criminal Justice Commission, to have these funds available. And knowing that we're capable of it and what we want to focus on in the next year or two is very valuable. So we've seen this through the health department, also where the state legislature finishes, the commissions and the dollars start to flow. And then, you know, this is November after a June session. But, yeah, we're getting there. And this is really good, though. In the next couple of years, we could you know, the definition of what's outside the bounds of a legal system is where we're at as a society and a community right now. And it does have national implications to, you know, Deschutes County, Oregon, just in the whole dynamic. So thanks for doing what you're doing.
If you do get the check today for the $109,000, be sure and let me know, because it said it's due today to us.
First
Yeah,
part.
the first one.
Yes.
So one last thing as a matter of process is that we know that we're working on a budget adjustment because this is new money. It was not included in the budget. And so
Yeah.
at a meeting sometime in the near future, we'll be back to make that adjustment.
Great, okay. Well, thanks for all of you coming today and kind of informing us. You knew we were going to approve this, I'm pretty confident, but it's great to hear, kind of use this as an update for us, so. Anyway, I'll seek a motion in support of this.
I move board signature of document number 2019-807, Criminal Justice Commission Illegal Marijuana Market Enforcement Grant.
And I'll second it, and it looks like Tom may have a...
Yeah, just a mechanical question there. The requested action is board signature. The grant agreement looks like an individual on there accepting on behalf of the county. So I don't know if that, maybe you could amend the motion to board chair or something like that would conform to the
Okay.
contract.
I move that the board chair signs the document number 2019-807, the Criminal Justice Commission Illegal Marijuana Market Enforcement Grant.
And I'll support that also.
Okay, any further comments? Dave, any comments?
I didn't review it. Kerry Coliani would have reviewed that. It came through the sheriff's office.
Okay, all right, Commissioner Dare,
Yes.
Commissioner DeBonne?
Yes.
And the chair votes yes. Thank you.
Thank you.
Thank you.
Thank you for your support.
You bet.
Thank you for your work.
So let's see, it looks like, so those, we've got, couple of items for this afternoon from the consent agenda, but we'll move on to our action items, first, I guess we're gonna convene as the governing body of Sun River Service District. Consideration of board letter reappointing John Ralston to Sun River Service District Board.
So moved.
I'll second it.
Okay. And I think isn't there a motion in here to do that?
It's just a letter appointment.
Okay,
We don't have a document number on that.
okay. So I'll just seek a motion, reappointing, Mr. Ralston to the Sun River Service District Managing Board, position 6.
And that was my motion in support.
Oh, I thought it was so moved to reconvene. Okay, so you've moved to,
Yeah, so when you read the agenda
Okay.
item, that was my motion.
okay, and did you second it?
I did.
Okay, any further comments?
No.
Okay, Commissioner DeBonne?
Yes.
Commissioner Dare?
Yes.
And chair votes yes. So let me organize our stuff here a little bit. It's an unusual consent agenda to pull so many items and to put them at different times on the agenda, so I think at that point, we'll go on to item number 9, which is continued deliberations for Phase A1 of the Thornburg Destination Resort. Jacob Ripper.
We could just note that our reconvening is the county commission.
Oh, yeah, do I need to say that, or?
No, it's
you
done.
Okay, good, good, thank you.
Good morning. Jacob Ripper, Senior Planner with CDD. Today, the board is deliberating on the first phase of the Thornburg's Resorts tentative plan and site plan review. As the board is aware, these are appeal proceedings following a hearings officer's decision that was remanded from LUBA, or the Land Use Board of Appeals. So after review, the hearings officer found that he lacked jurisdiction to issue a decision based on the merits of the remand, and that decision was appealed by the applicant in this case. And mostly due to time constraints, this review is based on the record, meaning that only those materials that were previously in the record are up for consideration, in addition to those written arguments that the parties submitted a few weeks ago. There were numerous topics raised in the hearings officer's hearing and in written submittals throughout that process, some of it outside of the scope of this remand. So staff has prepared a memo and a decision matrix in preparation for these deliberations. Those have been previously provided to the board. And I do have extra copies on the table by the door if anyone from the audience wants one. So that matrix lists 4 decision points for the board today. Those being, does the county have jurisdiction to issue this decision? If TP condition 17 is removed, will the tentative plan comply with the no net loss and degradation standard? If the mitigation water source were to be changed, would that constitute a modification to the FMP or final master plan? And then finally, there was an argument that new evidence was submitted in the applicant's final legal argument, which isn't allowed. So that should be addressed in today's deliberations too, if there was new evidence and what new evidence, or if there was new evidence, what it is, and that the board is not considering that in their final decision. So we can move on to the matrix if the board is ready, unless there's any questions we should address up front.
Oh, just a comment. You know, there's quite a record on this, and it was written in the hearings officer process. And I'm just thinking back to the few times. There were some pretty basic questions getting started just 2 weeks ago on this. But yeah, I'm feeling a lot more prepared. It's interesting that it's boiling down to this matrix. It gets pretty black and white in the end. So you've done a great job helping prepare for this.
Thank you.
Thank you.
Do I make initial comments?
No.
The one thing that I had trouble with, and I don't know if it was the objections issue, because it's so hard to track. There's a lot of information in the record, and so there's that. And does that make sense to have that the last thing, or I was kind of wondering if that should be dealt with first, but and what was your thinking? I mean, I think the 2 primary issues are 1 and 2, and that's the question to me. There's been an issue raised about whether we have the records too much or it's too complicated. If we were trying to evaluate everything, it's one thing, but really it's pretty narrow what we're deciding. And so I felt after reviewing it that we're able to look at it and make a reasonable, well thought out decision. But the objections is complicated.
Well, and
so
yeah, I mean, I'll put words around that. That was exactly my thought, as in, I can see the path through some of these, but when it comes down to record objections, I think it's going to be support by planners and legal on this, saying, okay, well, since we're doing this, what do we have to put in writing, or what can we just say, okay, no response. So I'm just thinking we'll have to get through this together.
Rely
but
on
I'm with you on that, because it's not black and white about where we'd say, okay, this is in or out, or
when there were some that were conceded by the applicant.
Yeah.
So it was like, well,
but how detailed do we need to get?
Yeah, the applicant did state there is a group of evidence that they agree was new and not allowed in that submittal. There's a group that may be considered new evidence, and just to be safe, let's not consider that in the decision, and then that some was included in the record previously. It's a detailed response to the record objection. The other option is that the opponent's attorney, Mr. Kleinman, in this case, provided some draft findings for the board that essentially says, just don't consider anything that I objected to. It's the shorter approach, and then the
Yeah.
applicant has this more kind of surgical analysis.
Well, the whole issue, and this is like you're saying, where we're going in the long run is a set of findings. It was Attorney Fancher's findings are very long and very, suggested findings, and then Mr. Kleinman's are kind of short. So it's like, I think figuring that out, it may result that we aren't going to get this all finished today necessarily in terms of, so we're going to have to talk about that. But it just, they certainly are different than the findings we've seen in other matters. I'm not sure what. So with all that precursor.
New evidence, the concept of new evidence, we're talking about a record and a point in time, and as time goes on, somebody put something else on a piece of paper and then it was included in the record. So as I say, I'm still unclear about what we would write in our final decision, but this is for us to work out.
So with that, why don't we start on the matrix and we'll go from there.
All right. So the first topic has to do with jurisdiction, and the question is, does the county have jurisdiction to issue a decision? As the board knows, LUBA remanded the hearings officer's decision. That decision was appealed by Ms. Gould to the Court of Appeals, and the Court of Appeals dismissed that appeal as being untimely. So the applicant initiated remand proceedings. The county issued a notice of the hearing. But at the hearing, Mr. Kleinman, Ms. Gould's attorney, raised an argument essentially stating that the county didn't have jurisdiction to issue a decision on remand because he had filed a petition for review to the Supreme Court to review the Court of Appeals dismissal as untimely. The applicant's attorney, Ms. Fancher, her arguments are essentially that the appellate courts never acquired jurisdiction after the LUBA decision, and that the filing of an untimely appeal doesn't create jurisdiction. The hearings officer did find that he did not have jurisdiction, so he didn't reach the merits of the remand. And the matrix lays out a few options here. Does the county have jurisdiction to issue a decision? If yes, we can continue on to the remand issue. If no, we should not continue on to the remand issue, just issue a decision saying the county doesn't have jurisdiction. And then there is a third option in there that after talking with legal counsel, we wouldn't recommend taking.
You mean C?
Yes, C.
Okay.
Yeah. It's
So we should X
we
that
may
out.
may not have jurisdiction, right? Yeah.
Okay.
So yeah.
Oh.
So this is where we'll discuss this a little bit. Does anybody want to start?
Can step in. So,
I could, go ahead.
yeah, I mean, we've just starting this process. The answer is yes. Jurisdiction by the county, the time clocks of the state land use system. The appeals process is there for issues, but I mean, this all started with a, late filing notice. So if the Supreme Court brings it up and if there's a different conclusion at a different level, that's kind of, I just see that as external to what we're doing.
I could agree with that. I mean, I do believe that we do have jurisdiction and we should continue review. And yes, the Supreme Court is a totally different issue.
So then I would envision findings just being pretty clear. This is what we know, this is why we did it, and it's done. Because then, as I say, if there's a bigger picture around this, it wouldn't be the responsibility of this governing body.
So, and I'm comfortable, I agree with the other two commissioners in terms of us the county having jurisdiction to hear this. My thinking is consistent with Ms. Fancher that who had the jurisdiction was the county, and then it went to LUBA, and then it's been remanded to the county. And just by filing appeals, you don't get jurisdiction until somebody decides the appeal's gonna be heard. At this point, it hasn't been heard by the Court of Appeals, and the Supreme Court may or may not. But I personally think the Supreme Court won't hear it, because this rule about how you file something is a huge deal in the legal world. And if they say, well, we could have done it as what was done was a mistake apparently, but that's really unfortunate for the lawyer if they intended to get it done on time, and it really falls on the lawyer for the appellant. So I would be surprised if the Supreme Court opens this up. But on the other hand, I feel like if the Supreme Court does open it up, we will have been kind of negligent or whatever if we didn't hear out the substantive matter during the timelines, because I think it will be argued by the appellant that, oh, well, you're like it's suggested here that maybe it's void if you wait, and I think that would be argued. So I think it's our job. So I agree with that on jurisdiction, and I think I'm comfortable with it saying that one of the things that appellant's lawyer says is jurisdiction can't be two places, and I completely agree with that. But the only place that we know has it was the county and the LUBA, and the Supreme Court can decide they want jurisdiction, but they haven't yet. And so, to me, it's where it is until a Court of Appeals does take it. And I was kind of surprised at the hearings officer's decision as I looked at the cases. It just seemed to me that it wasn't he was relying on things other than that. But the hard rule says you have to do it with on time, and unless you do the 3-day, and this wasn't a 3-day by doing regular mail, so 3 business days. So do you need any further direction on that if we're going to?
That's clear.
For you to take direction.
Thank you.
Do you have any other comments?
No, that is like the number one rule. The burden of proof is always on the taxpayer. You have to mail it. You need your receipt back that they received it timely. Yes, that's something it would be really quite surprising if the Supreme Court took it, because that is like number one rule of all, documentation. You must document that you've timely filed something. It's just like when we're saying that you must send in your email before 5 o'clock, because a lot of times it circles the earth before it comes in Deschutes County's box. So
Received
right
before 5 o'clock. So think about Well, that's basically the same filing rule, and I think the Court of Appeals and the Supreme Court are the most strict of it. I mean, our circuit courts are too, but statute of limitations it's just a normal practice for lawyers, and it would really be I think kind of unfair to the applicant to be able to go through this lengthy process if jurisdiction is never taken by the Supreme Court, and then we're still where we were when the remand was made. So, okay, well, looks like we decided that.
Great, thank you. The second topic has to do with the LUBA remand. So in the hearings officer's decision from 2018 for the tentative plan, he noted in that decision that in the FMP, the final master plan's approval, that it was found that mitigation was feasible and that the mitigation plan identified specific sources for mitigation water, but that through those proceedings, some of the opponents had raised some doubt around the feasibility of acquiring that water, and that played into drafting this TP Condition 17. It has to do with issuance of building permits for single-family dwellings, and demonstrating that the Big Falls Ranch and COID water referenced in the mitigation plan and FMP decision had been secured, or if a different mitigation source is used, does that constitute, or if another mitigation source is used, that it would not constitute a modification to the FMP. LUBA remanded based on that condition, as you all know, because they believe that it violated a right to public hearing, the right to the public process for the resort to change their water source. So their instructions were that the county can't rely on on condition 17, and that the county needs to consider if, without TP condition 17, the tentative plan for phase A1 satisfies that no net loss degradation standard, and whether a change in the source of mitigation water constitutes a substantial change requiring a modification to the FMP or a new application. So I broke that into two steps in the matrix. The first is just focused on if TP condition 17 is removed, will the tentative plan comply with the no net loss / degradation standard? And the options I wrote: A, if yes, the application may be approved; B, if no, the application may be denied.
To me, this one is a closer call than the jurisdiction was in terms of the facts. One of the things that I noticed that didn't seem to be pointed out a lot by the attorneys arguing it, but it really isn't in here that the tentative plan, which is what we're approving, has to show, or you have to secure the water rights before the tentative plan under this section 17. It's that you would have to do it before the building permit. So I thought that was, which is a long ways down the road, but it seemed like there's quite a bit of evidence that, I think there was a good point that about 17 maybe not being to be relied on because there hadn't been a process for citizen involvement. But that said, it seemed like there was quite a bit of evidence that the water right or water source is consistent with what the plan had called for. There wasn't a COID water, but there is the Big Falls Ranch, or is water right. Seems to be, there is a process for that to be acquired. And they've already taken steps to kind of free up that water, I guess, which seems to almost have hurt them in a way, because if they're, I don't know if they needed to remove the dams before this process, but apparently one of the dams has been removed. And so this is a good quality water, and there's sufficient in that resource. So I thought it looked like there was, is the standard, I assume, is more likely than not, or what's the evidence standard? Substantial evidence or more?
Yeah, I think right now it's substantial evidence to find that it's feasible for them to acquire the water, because actual mitigation is required when they start pumping groundwater.
So yeah, the question specifically, if it's removed, will we comply with no net loss? The applicant, sorry, but it seems appropriate. Seems like this is, as I say, the point in time in the past where this was being discussed, and now we have information in the record explaining that yes, it's available. Yes, it's good, no net loss for the standard. And I do support that condition 17 be removed, which gets us to yes here.
Sure,
Darren? No, I can agree with that. It does seem like, they do have adequate water available. The fact that the Big Falls Ranch water, I believe is cooler water that they're using. So anyway, then bringing in more the irrigation water from COID. So it was, my question is on the next point, though, on 3, is that too much of a modification? Is that a bit of a modification? I don't know. To me, those two go together.
Yeah, so we can say some words along those lines. So this is and I've seen this before. This is water, and it's a reference to the future or outside contract or how much something's going to cost. So this is a plan, Fish and Wildlife Mitigation Plan, saying we need X amount of water. It needs to be of this quality, and that's the plan. So when you implement the plan, that's when somebody pays somebody, puts a contract in place, and the rest of the story. But that has this is water. It has to happen. There's no way somebody's going to be approved to proceed and be able to, almost have their water, or I meant to write up the contract. So I'm just documenting that the plan is it shall be done, and just acknowledging that it will. So it sounds like it's not a contested item anymore, that the Fish and Wildlife Management Plan does meet that standard. Sorry, I've kind of varied a little bit, but
No,
yeah.
I think that's, well, one of the questions I had is that it seemed like the appellant has relied on kind of picking apart every piece of it. And one is the issue, well, the Fish and Wildlife Mitigation Plan says COID and Big Falls Ranch, but they're only going to use Big Falls Ranch. Well, I wonder if when they said both in the Fish and Wildlife, it could have been an and/or, because really what they need is enough to mitigate what they're taking out at the resort at some point. So I didn't think that was a modification. To me, it doesn't really make sense that that would be a modification. It would if they went to a different stream or a different plan, different approach that way, but I didn't see it. I think that's one of the things I had trouble with it too, is how much should an applicant do before they know they can even do the project? I mean, and it seems like there's been a good intent by Big Falls Ranch to give this water right, or mitigate this water right this way. And it looks like they're already doing that. I know there was evidence in the record that, well, the dam hasn't been removed or it's still there. Well, I think there's substantial evidence that there's a dam there that beavers have built, apparently.
Yes, the beaver dam.
Looks like a beaver dam that would have to be taken out at some point to let the cool water go down. But the other,
Yeah, and there are steps to that mitigation plan when certain actions have to be taken. So not all of the water needs to be attained right now. Not both dams need to be removed right now. It's contemplated throughout the build out of the resort.
also, I kind of wanted to address there's some other technical things that are raised, and there's good technical objections, but one was the issue of, well, you've got trust deeds against the property at Big Falls Ranch, so therefore you can't sell the rights. I don't, and then there's also the Kennedy trust deed. To me, those are, it would mean you couldn't almost do business if you interpret that as always it's almost like they're owning it, saying they own the ranch, or they own all rights to the ranch, which is not really what it does. So I felt like it's an interesting argument that was made by, I think Landwatch made it originally, and then attorney for the appellant also made it, but that was interesting. The other one was the nature of the water right changing from a point of diversion to a point of appropriation. I feel like we should talk about some of these just because they were big issues in the deal, and we kind of have to deal with them in a way. It looked to me like the change of water right was done because you've got to keep your water right active, and if you're no longer diverting from the stream, you would lose that over time. So you almost have to change it to an appropriation, and then they'll have to change it back at some point to sell it. But that's what, we've learned a lot about water rights in the last several years with other cases. Anyway, and then there was issues about the order of the dam removal. I thought that was kind of a minor thing with regard to, I think they've done more than they had to do for this tentative plan, really.
It seems like they did, that actually they are steps ahead of where they need to be, just to support their intentions.
The other thing that was raised that I could think of was the issue of the contract's not here, it's just the memorandum contract. We don't know what it says, or it doesn't have the right provisions or the right this. That can go on, I feel like, almost forever. And I don't know that they have to, I guess legal hasn't said they have to provide the contract. There's testimony in the record that there is agreement to transfer these rights. So this is a tentative plan, approval of a plan, tentative plan. So they will still have another process where they have to, actually do it.
Yeah, and there'll be site plan reviews coming up for the overnight lodging units, for the guest services that are required for destination resorts, meeting rooms, restaurants, that sort of thing. And yeah, further tentative plans for further phases of the resort as well.
Well, one of the objections was, or not objections, but arguments in opposition was, well, there's nothing at the county that would ensure that this water right actually happens because we don't have water rights people, we don't have fish biologists, et cetera. But we create conditions on a lot of decisions we make that we expect CDD to make sure those are done before we give a building permit, or, you know, with the marijuana permits, we have a right to inspect. So I would assume if it's a precursor to the building permits or whatever, that would still be, that'd be a time that we could inspect or, determine that. I don't know. Assume, so any other comments on number
Yes,
2?
yeah, number 2.
Yes, on number 2, okay. It sounds like you're the same place, Commissioner
Right.
Dare.
Yeah, and so we started talking a little bit about number 3 already. If the water source were to be different than those identified in the mitigation plan and the final master plan, would that constitute a modification to the FMP or a new application entirely? There hasn't been a lot of argument through this procedure that it would not constitute a modification. I wanted to include it in here because I thought it was important that it was part of LUBA's remand instructions. So the question that I've written in the matrix is, if the mitigation water source were changed, would that be a modification to the FMP or would it require a new application?
Are we supposed to pick between those, or
Application
or new application, or are we supposed to?
Certainly can. The remand instructions were, would it be a modification or require a new application? So I repeated that language in here, but we can certainly be clear and, for example, provide findings that say, yes, a change in the water source, in the mitigation water source would require a modification to the FMP.
They actually term it as substantial modification, but I just believe it's a modification.
Right.
I have a hard time with, what are the scenarios we're talking about here? As in, water in a geolocated area relative to the proposed development. This specifically, Big Fall Ranch is close. COID would be the water exchange entity. State Department of Water has the authority in here. So mitigation water shall be lawfully acquired, and I'm thinking bigger picture, not even this application. Mitigation water shall be lawfully acquired is as far as we might want to go in the county code, because then there's the other entities that document that it's appropriate. And so that brings me back to what change, the definition of change here, because we may be putting some words around something that's, I don't know, just speculative, that may never even happen in the future. I don't know.
Right. Yeah, and in testimony and written materials, the applicant has stated that they're not proposing a change to the mitigation water.
So it's kind of disconnected from this application. It's like a decision point disconnected from this application. But if it's valuable to put on the record, let's get there. Maybe it isn't.
Yeah, it was a little bit hard. I mean, what I would see this being is, so they're looking at this decision that 2 different sources of water have been offered for mitigation in the Fish and Wildlife Mitigation Plan. They could change, actually, I don't think it has to be close to it can be anywhere along the river. They're just dumping in more water or getting more water into the Deschutes River to compensate for what's being taken out of the resort. So I guess they're just kind of saying, well, what if that doesn't happen? How are you going to treat it? One of the questions I have is whether and maybe this is what you're asking, are we in a position we should even be deciding this? What would happen on a remand if you don't answer the question? Because I
understood Luba to be asking the board to give almost a declaratory or advisory opinion on that. anticipating that'll be yet the next appeal issue if the source of the water were to change, and that maybe this might circumvent that by one appeal cycle. I'm not sure. That's what I read it. Maybe Adam and Jacob are much more familiar with it, but I read that as them inviting kind of a de facto declaratory ruling.
Relevant to the, whether the decision. The elder.
These are the experts, so I'll defer to them.
I agree with what Dave is saying. Just including a finding maybe around the lines of if the applicant were to change their mitigation water source to something outside of what's approved in the FMP and the mitigation plan, that they would need to file a modification to the FMP in order to use that water source, because modifying that mitigation plan in the FMP would require, again, a public process, mitigation with ODF&W, discussions with Oregon Water Resources Department, kind of be a redo of that whole mitigation plan.
What were you going to say, Adam?
Good morning, Commissioners. Adam Smith, Assistant Legal Counsel. Certainly, you're put in an awkward position on speculating that if a modification occurred, how will we treat it in the future? And I think that's in part dependent upon, the nature and the scope of the modification. I think we could certainly issue a finding that just references back to the Deschutes County Code. We have procedures in how applicants deal with a modification of approval. And I think a finding just referencing that section, DCC 2236.040, I would hope would be sufficient. I mean, we have a process in how we deal with these kinds of situations. But being asked to speculate on how will we treat that situation now, I think it depends on if the applicant applies to modify the approval and what that modification is at that time.
Well, I'm assuming a source change means it's not from Deep Canyon Creek, it's from somewhere else. And so, and it's not from COID. So, to me, it doesn't make sense you'd reapply for the final master plan, because that's got to be one of 50 issues in the final master plan. So it seems to me to be a modification, not a new application. I mean, that would be what I would, if I was asked to decide, I'd say it was modification. But like I think Dave's saying, it's kind of advisory because there's no proposal to modify at this point. So, anyway.
Well, and as I say, I struggle with what is the definition of water source changed, as in,
well, that's what
are we talking about putting, it's not going to be surface water at this proposed development, it's going to be a well. So then that's terminology. So water source is the authority to use the water. So as I say, and I don't know enough about the water law and the implications of that, but
Our implicit standard for it to be a modification of approval, an application modify an approval shall be directed to one or more discrete aspects of the approval, the modification of which would not amount to approval of a substantially new proposal, and this is probably the key language, or one that would have one that would have significant additional impacts on surrounding properties. So if the applicant, in fact, proposed a change at some point in time in the future, that would be the analysis at that time, whether or not it was had significant additional impacts on surrounding properties. But until they've actually sought that modification of approval, I mean, we're just put in the opposition of having to speculate. I think probably the easiest way to, as I noted before, is to just reference this language and the procedures that already exist in our code, and depending on the nature and the scope of the modification will dictate if it requires a new application or just a modification of approval.
Okay. That's fine with me. I mean,
Yeah.
that,
well, and I mean, I can get to yes, as I say, when we put it in writing, it'll be interesting to see, and I'm sure you're thinking about that already. Because if the answer is yes, if a modification or new application, because that's the question, it's both paths already.
I think it's, I mean, sometimes people hate the answer, but attorneys love to get it. It depends.
Yeah, I know,
It depends on what they're going to, it depends on first, they have to actually propose a change. I mean, my understanding at this point is they're not necessarily proposing any changes. And then it will depend upon the nature of that change if it goes into a new application.
And this might be defining how we're reading the question, you know, the LUBA's guidance, and then defining how the answer is written. You know, so as I say, it's going to matter how it looks on paper.
But I do think, so especially in these multi-stage reviews, if you look at the case law, LUBA is certainly concerned about making changes at subsequent stages where the public and opposition doesn't have an opportunity to participate.
I would
think
agree
in
with
either
that.
circumstance, that's not going to be the case here. I mean, an application for a modification. So even the easier box, if we decided it was a modification of the approval, is still a land use action, and there's opportunities to participate. If it's a new application, there's certainly going to be opportunities to participate. So I don't think there's any way that the applicant in this particular circumstance will be able to unilaterally change or make that substantial of a change to what they've proposed and have already been approved to do without the public having an opportunity to participate.
Right.
In a big, impactful way. If there's a big change, it seems appropriate.
You know, when reading the actual wording in the remand which is on our staff memo, among other places on page 1076, it says, on remand, the county must consider, number one is the conditions 17 stuff, and two, whether a change in the source of mitigation water constitutes a substantial change to the FMP approval requiring a new application, which is one, modification of the application, which is two, or further review consistent with the FMP and DCC destination resort regulations. So which is three to me, that's a third option. So are you saying we should adopt the third option? Do you read it that way? You see what I'm saying? That's the exact wording from the decision.
Page 32 of this.
Perhaps we could read it. I think either one or two will encompass three. No, let me state that differently. Three encompasses both one and two. If there is any future change, it will require further review of the proposal with regard to Deschutes County's destination resort. I don't have the exact language in front of me.
Well, I would read it that it requires a modification of the application and further review. I wouldn't want to just limit it to further review, if that's what because that really is no decision at all. Do you have the word? Did you give him the wording?
Yeah.
You see what I'm saying, Jacob? You know what I'm saying?
It seems like it's going to keep being reviewed. That's what I read all these documents. So.
The commitment to this water source has existed for 10 years now or more.
Right,
So
at least.
And it seems like this ranch entity is willing to give up the in-stream water rights to this use. I mean, they're willing to sell them. They don't apparently need the water for running their ranch, is what it looks like to me. So, or they're willing to reduce the scale of their ranch or whatever it is, but they apparently have enough water rights that they can do that, and they've been willing to do it for 10 years, and I would guess they'll stick through it for a while. They've committed, I guess, in the memorandum through 2020.
Commissioner, to be more clear, yes, I think we can answer it as option three. Other further review consistent with FMP and DCC destination resort regulations, specifically DCC 2236.040, which dictates modifications of approval and has procedures laid out and standards for how we decide.
And that includes a public process to do modifications.
It calls them out as a land use action, and I believe that implies it goes through a process just like any other land use action.
We said notice with that, it's a land use permit.
Okay.
I'll proceed.
So for this application and this remand from LUBA, I support putting words in there like we're talking right now, but I do also see that the source of water is not changing, and it is in compliance with the original plan. So, kind of answering LUBA's question and confirming the situation.
What I'm hearing, Commissioner, is that the focus should be on question number two as presented on the matrix with a much more succinct and summary finding for question number three, which I would tend to agree with.
I think that's the real meat of the issue. Before we did objections, so one thing that concerns me, because this has been such a litigated issue and there's so many technical things that were brought up in the with regard to this water source, and whether it's changed, whether it's secured, whether it's going to be continue to be secured, et cetera, we kind of are just talking about it very summarily as commissioners. We may have put a lot more thought into it than that. Does it matter? I mean, when the record goes to the LUBA, which is probably will, that we sound like we're not going very deep into it, or does it? I mean, or do the findings represent our final thought? Because it's
The findings represent your final thought. I mean, the
Okay.
deliberations are necessary. The way I view it, your deliberations are necessary to give the staff and oftentimes the prevailing party enough direction to go and write the findings, which, as you know, we oftentimes spend several additional weeks just working on those findings to make sure that they are reflective of the commissioner's point of view. So the deliberations are enough to just get us started on those draft findings, and it's those draft findings that are really setting forth your point of view going forward.
because I want to make sure that it's realized that we've seen what's in the record, and we know how complicated it is, and because there's been comments made that, well, I think by somebody that, well, really you can't really gather, understand it all, almost is what was implied. And it's like, well, because it's such a narrow issue, I think we can, so at least.
We did
Okay.
have a lot of work sessions over it.
Well, yeah, and we've had a chance, and we've had the binders, et cetera. Okay. So we've gotten through 3 of them, I guess, for now.
And then just for clarification for the record objections, did the board want staff to go through those arguments and come up with a recommendation, like a set of findings for what was new evidence and what wasn't, or?
So one thought I have is that there were quite a few on, Ms. Fancher had said she was willing to let go, or she kind of agreed with them or something. So that seemed like that narrowed the scope of how many are still argued, I guess. Another issue to me is that most of the things that were objected to, I should say this, but I mean, I'd kind of read enough stuff. A lot of there was enough evidence in the rest of the record to make most of the points made today. So it wasn't relied on, I guess is what I'm saying.
Commissioner, I would state that that's kind of a preliminary issue anytime there are record objections.
Yeah.
And, I mean, we see courts do it all the time, LUBA does it all the time. We don't necessarily have to reach that issue if whether it's new or rebuttal evidence is dispositive of anything. If it's not dispositive of anything and the commissioner's findings hold without relying on that evidence, then we can easily just know that the commissioners are not taking a position one way or the other, but agreed not to review that evidence, and it was not necessary to reach the conclusions issued herein.
What's your feeling on that?
I'd like that path if at all possible, so that kind of just gets into, are there any substantive statements in any of the records associated with information? That's why, that's like, how do I make that matrix, just like you were offering to do it. But if we cannot do that, I would very much.
I mean, certainly rebuttal evidence is allowed, new evidence is not. It's not always crystal clear which camp you fall into. And I think that's why courts frequently, and I think that's why it's not infrequent to just note that, hey, there's other evidence to support our findings. We didn't need to rely on any of the pieces of evidence that are at issue, and then you proceed from there. And then you don't have to choose if it's rebuttal or new.
So is this something you think we, again, because this is, most things get appealed in this application project generally, do we need to go through those individually and deal with them, or, in other words, identify the objection, look at it whether we relied on it, or because they kind of came up, I think, last week or something. I mean, they came up with I guess with the final written, after the written stuff was turned in, that's when it came up, wasn't it? Or
Right.
So remember, we're talking about the Fish and Wildlife Mitigation Plan being appropriate for no net loss degradation standards. And my understanding, and as I said, I don't even have it prepared here, but it was talking about, kind of what's happened since. So that means it is new information. But if we're going back to just that item, and we've made a decision about, condition 17 and how, it's not compromising no net loss degradation standard, maybe we can get to just saying, even if there's new information in the record, it wasn't substantive to this decision.
I mean, I would defer to the commissioners. If you're confident you know which specific pieces, which evidence, which specific documents are the subject of these objections, and you can say conclusively, I did not need to rely on any of those documents to support the findings that we've already talked about, I think that's a sufficient direction for staff to go and write that finding. If you want us to identify each of those specific documents, I trust that Jacob can walk us through the list.
Mm-hmm.
The first two documents that I spent a lot of time on were number 87 and 88. And so, and then when you go back and review, it didn't seem to be, everything that was told that was new didn't seem to be an issue in making the decision we've made today.
I would just say certainly if the board's inclined to have the finding Adam articulated as a threshold, and that is that what's been identified or argued as a new finding may or may not be, but it wasn't considered by the board and wasn't in any way relevant to your decision today, that's great. If you do want to go beyond that, I'm comfortable that if you don't, it's not going to be the basis of any reversal. In a record of this magnitude, I think it's almost impossible that something wasn't raised in the record at some point that has enough of a nexus to what's allegedly new that it wouldn't be deemed new. Now, whether that would, survive beyond a remand, that's what I'm not real clear on, and perhaps that's what Commissioner Henderson's getting at. In if we do identify those chapter and verse, and then have some sort of a response directly to those, is that going to head off a potential remand on that very limited issue? Not sure.
Yeah, I would tend to think, the entire nature of the remand is to consider what the board is now deciding was superfluous a condition, right? All of this, they applied, the applicant applied and said, here's our water portfolio. This is what we're planning to do. At subsequent stages, opponents argued, hey, we're not sure they can do what they initially proposed to do. The hearing officer thought that there was enough evidence at that time, maybe it is in question, imposed condition 17. Goes to Luba. Luba says, hey, condition 17 is foregoing a public process. If any of those things come to pass, you need to consider if you can approve the application without condition 17. My point in all of this is really the evidence that the board is relying on to agree that the application holds water, pun intended, without condition 17 goes all the way back
To the original
to
decision
the original.
of the
So
hearing.
all of this subsequent twists and turns and arguments back and forth are not necessarily necessary to support the board's condition that the condition 17.
Well, it seemed like the appellant's objections kind of related, a lot of it was to the Newman letter, or whatever it was, that attorneys, the Newman letter, and which was trying to clarify a bunch of things that had been raised by the appellant. And so I think that's why they're saying that was new evidence or something, or it's kind of what it seemed like to me. But but you're right, yeah, there was, we were really being asked to just decide on the original record too, so, anyway. Okay, well, so what you're advising is the better course?
I like the proposal Adam suggested on the threshold level, and if in fact it wasn't relevant, anything identified as new by the parties wasn't relevant in the board's thinking and its decision, that should be sufficient. And we could try to anticipate remand issues and go through the list of identified new evidence issues, and we may create a procedural issue there. That's the history of this application. I think I called it tortured last time, and it's think if you looked that up in the dictionary, this application would be there. I mean, this has been very much a tortured application process for 15 years.
Well, that's, I guess, what I'm trying to make sure we try to keep it as clean, we make it as clean as we can, that the objective to, the other alternative would be that we rule it's not new evidence. Is that what we would do? We'd rule on each objection saying, well, that's not new evidence because I saw that over here.
Or it's rebutting over there.
Yeah, I see what you're saying.
Which would be Jacob's the master of the record, but if we're going to cite the record, you're going to be this afternoon finding those page references.
Mm-hmm. I don't want to do that, but it seems like to keep it clean, maybe we should come back with those objections and decide that with some thought. Does that make sense, or what do you think?
I like the idea of making a blanket statement, if at all possible, legally defensible blanket statement saying this was not utilized for this decision specifically.
Really the board's prerogative.
Yeah.
On that point.
Because this issue, they clearly say it's only this, TP 17 is all that we're supposed to be dealing with. And to keep it as clean and simple as possible, to me, is really important. And, so that clearly we don't bring in something else into the equation. And I'm not sure legally what is the best tack, but, I know that we're just dealing with number 17.
Yeah, the simpler, the cleaner, the tighter, probably the better.
Don't you think?
But I don't know that ensures that
I know.
whatever you do or don't do won't be the basis of yet another LUBA proceeding.
Well, if I have any more questions, I think I'm going to review some of it over lunch, and then if I have any more questions, I'll bring them up then. But I'm good at this time with the reliance issue, or using that statement as the basis.
Yeah.
All right. So I think that concludes the four issues, give some direction.
Okay.
So, do you have something prepared to talk about at 1:30, or is that really unrealistic, and we should do it, see if we could do it tomorrow or Wednesday? And
Can't do it.
Commissioners, what are your
No, we have to do it
schedules?
tomorrow.
Yeah, it's got to be in the mail by Wednesday.
Right.
I can certainly bring back a draft this afternoon.
Are you working with the draft that was suggested? I mean, or are you creating one, or have already started creating one?
I've already created a skeleton for it with the basic things that weren't decision points. So I just need to plug in some of these findings from today. Adam's going to help me with some of that review.
I think it would be prudent for Jacob and I to get as far as we can and bring something back for you this afternoon for you guys to take some time to read and provide further direction that we can work on, and then hopefully bring the final draft to you tomorrow. As I noted before, the deliberations are just to get us enough direction to get going, but ultimately the findings are your decision, and so I think we should try and preserve one opportunity to look at today and one opportunity, if need be, to look at it tomorrow.
Yeah. I wonder if we should, because we ran a little longer than we thought, we have less time till 1:30. I wonder if we should postpone it a little bit, which not start at 1:30, but maybe start at 2:30 or something on that, or what's
We've got those.
Request being one of the later items on your afternoon's agenda, if you can.
So right now, you're the only thing on it, except for the two explanations that we had this morning. So we'll do those definitely first, but that won't get us, they're not very long items.
Yeah, something like 3:30 even is fine with me.
Well, 2:30 makes sense.
All right, let's
How about 3?
plan on that. It's set for 1:30, but we'll meet at 1:30 on some other items, and then we'll postpone the further deliberations. 3.
Anytime's fine.
I think, let's do 2:30 and see if we can get some things done by then, and then move forward. Again, the other thing about this, having read all this stuff, to me, is that we're not looking at the whole decision, we're just looking at this one, and even with just this one, it was really complicated, so amazing. All right, thank you.
Yeah, thank you.
Thank you, Jacob.
All right, so, let's see.
Mr. Chair, I might propose that we jump right to the public hearing on the mass gathering permit, so then the folks that are here for that, because the other items are just kind of,
Okay,
I mean, we can do the second reading item before we leave here, and then we.
yeah, the other ones are model flood plans, and that was open last week, and because I wasn't here, you kept it open. I don't know if we're expecting additional testimony today or
It's
not.
just a second reading, so it's already, it's just very much.
Oh, it's just a second reading?
It's a second
Okay,
reading.
okay, good. So let's, yeah, I'm good with that. Are you?
Mhm, that's
good
fine.
with that decision? Is that okay? Okay. So we're going to move to, I don't know where my agenda is now. Final item, all right. What item is that?
12?
Number
Number
12.
12.
Okay. And, which is the consideration of the Four Peaks Music Festival mass gathering permit. So we're going to have a presentation of it, and then will there be testimony also?
Possibly.
And
So
we've,
I have gone through the binder, I didn't bring that one down here, so I
Okay.
don't know that I'm gonna need it, but if, just in case we look at something, I'll need to look at a reference of your
Okay.
book.
Are these the same as you gave us?
Yeah. so-
And I'll just
'cause I
note
had-
for the board and the benefit of the audience, while this is a public hearing, it's not a land use process, and so it operates just a little different than our traditional land use hearings.
Yep, okay.
if anyone plans to testify on this, we need to fill out a blue form, which is up here in the box. We've had two requests already, so. Is it working?
It's getting there.
It's loading.
Right.
Working out.
Come on.
So Kyle, while you're getting it up, I have a question on the map.
Of course.
What's this gray line that goes through the colored map?
The gray line is, yeah, it's an access point from the main entrance to the festival that allows vehicle access to the parking and camping areas on the south part of the property.
Are they saying that's a road? I mean, it goes from one edge of the map to the other, and I don't think that's how they do the road, right?
It's not a formal road. It's a portion of the driveway access from that northeastern corner of the property.
Yeah, I thought, I don't know, did you make the map or did somebody else?
They made it.
That's made by the applicant.
I thought the actual access is over is not at Heidi Lane. It's over further, so it doesn't really line up with what I think they do. So it just seems like the whole thing seems odd.
Understood.
So maybe we can ask the applicant what.
I bet she'll answer those questions too.
Yeah. All right. For the record, Kyle Collins, Associate Planner, Deschutes County Community Development. And Chair, if you want to begin the opening hearing process.
Here, there's somewhere.
So is there
There was, he gave you a sheet.
oh,
There it is.
thank you.
I know, I don't have enough to do here.
I heard you say, here, this is for you, Chair, and I thought it was one of these maps. Okay. This is the time and place set for hearing on file number 247-19-000690-OMG. And staff will outline the hearing procedures that will be followed.
All right. The hearings body, the Board of County Commissioners in this case, will take testimony and receive written evidence concerning an outdoor mass gathering permit. The address of the property in question is 21085 Knott Road, Bend, Oregon. The applicant, Four Peaks Presents LLC, is requesting approval of an outdoor mass gathering permit for an annual multi-day music festival. All testimony shall be directed to the hearings body in this case. At the conclusion of this hearing, the hearings body will deliberate towards a decision or continue the hearing or deliberations to a date and time certain. The hearing will proceed as follows. Staff will provide a brief report. The applicant will present its testimony and evidence. Any appellants will present their testimony and evidence. Opponents and proponents will present their testimony and evidence, and any other interested parties will then present their testimony and evidence. The applicant, as the party bearing the burden of proof, will then be afforded an opportunity to present any rebuttal testimony. And finally, if requested by the hearings body, staff will provide any closing comments. A full written version of the hearing procedures is available at this table over here, as well as staff's report. Commissioners must disclose any ex parte contacts prior to hearing observations, biases, or conflicts of interest.
Does any commissioner have anything to disclose, and if so, please state the nature of the same and whether you can proceed. Commissioner Dare?
I have none.
Commissioner DeBonne?
There was financial support for my campaign last year on this. I've been through this process multiple times, yeah, I mean, I'm disclosing it for what it is. I don't feel like I've been compromised from making a decision.
Okay. Well, we've had this before us a couple of times, so people have talked to us about it. We've also received emails. I've received comments both in favor of it and against it, but nothing. And the only ex parte contact, other than that, I was contacted by Mr. Minor about the possibility of doing a sound demonstration of what
1570?
decibel levels sound like, which I've been informed that they're not planning to do that today, but I was interested in it because I don't actually know, and I suggest we might go outside to do that, but other than that, I don't have any conflicts or that would cause me to withdraw. So does any party wish to challenge any commissioner based on ex parte contacts, biases, or conflicts? Hearing no objections, the hearing is now open, and staff will proceed with a brief staff report.
Thank you, Commissioners. As we stated before, this public hearing is in relation to a proposal by Four Peaks Presents LLC for an outdoor mass gathering permit on a 150-acre parcel owned by D.M. Stevenson Ranch, identified as 21085 Knott Road. The Four Peaks Music Festival has occurred on this property for the previous 3 years, and prior to that it was held on a property outside of Tumalo for approximately 9 years. The current proposal would request the OMG outdoor mass gathering permit that would allow up to 3,000 people at the festival, and this includes musicians, staff, vendors, and volunteers. The proposed dates for the festival itself for the permit are June 13th through June 22nd of 2020. This includes setup and removal of all equipment, structures, and similar materials that would be used for the festival. Some volunteers, staff, and security would be staying or camping on the property from June 13th to June 22nd. And additionally, the applicant states that due to the extensive logistics and mobilization of setup for a festival of this size, it will be necessary to have access to the site prior to June 13th for deliveries and site preparation. Staff would point out that the applicant states site preparation prior to June 13th would include things like the removal of brush, rocks, general grooming of the grounds, and again, to receive deliveries, but would not include the setup of any temporary structures associated with the festival itself. The applicant states that site preparation crews will not exceed more than 12 persons on site prior to June 13th. And all work associated with site preparation would occur between 9 a.m. and 7 p.m. The construction of all the temporary structures, such as the stage, would not begin on site until June 13th. The actual music festival itself would take place between June 18th and June 21st. That's a Thursday through a Sunday. And the festival includes music sessions inside of a tent in addition to the outdoor stage itself. Included in this proposal are 3 late night music sessions inside the tent from 10 p.m. to midnight on Thursday, Friday, and Saturday, and 3 early morning silent, which involves the use of individual headphones music sessions from midnight to 2 a.m. on Friday, Saturday, and Sunday mornings. The specific dates for all events associated with the 2020 festival are included in the staff's report. The proposed festival itself, again, would be located at this property off of Knott Road. It's primarily associated with the eastern half of the subject property, which will be divided into specific areas for the festival. Primary access point for the festival itself is located off of Knott Road from an approved driveway access point associated with the northeast corner of the property. You can see that here in the traffic plan figures.
What are the orange boxes?
The orange boxes are associated with actual signage associated with their traffic control plan. So each one would designate speed limits, directions to travel, things of that nature.
And I see where the one, one orange, or I guess it's kind of, I don't know what color it is, but I see the one that's the access point. What's the one to the right over by, it goes, what's that? What's the point of that?
To the right of the main entrance area?
Well, yeah, I know the main, so to the right, there's a kind of reddish orange circle and then a line that says something.
So the two circle figures are the main entrance, which is to the far eastern portion, and further to the west is an emergency vehicle access point. So that would just be used by police, fire services, things of that nature. Near the entrance of the site, there would be general admission vehicle lanes, the ticket will call, trash and recycling collection, and day-use parking facilities. The main activity area, which is located in the center of this figure, would be associated with the stages, vendors, restrooms, water, first aid, trash collection and recycling, and all the basic operational aspects of the festival itself. Just north of the main activity area is an area located for authorized personnel, so that's all volunteers, musicians, people of that nature associated with the running and operations of the event. And other areas to the south of the main activity area are all designated for family camping, which includes RV and car camping, and another day-use parking area. A designated yurt and tent camping area lies to the very south of the main activity center. And this design, as in previous years, includes a separation of vehicle and pedestrian access aisles throughout the property, as well as the emergency access point for, again, fire, police personnel, which is located in the northwest portion of this particular figure.
So on that map, there's some things I can't read. know when you hand it out, and there's, so one of them is this right here. See it up here. Right up there.
Mm-hmm.
What does that, what does that say?
In terms of next to the crew camping area?
Oh, that
Is it
says
hookup?
camping.
What's the, no, the orange one, it says something hookup?
It says Honey Bucket, which is one of the waste facilities.
And it's a hookup, so does that mean does that mean where they put all the portable toilets, or is it?
I don't believe they would all be located there, but at least some significant portion would be located in that area.
And what's the orange above that say?
The orange above that is a shipping container, which I think is for the establishment of equipment for the stage itself.
So the other parking isn't really allocated on this, the day parking?
Mhm.
But if you say, what is it, 4 people in a vehicle is what the allocation is, there's really like 750 cars that are coming in here? And some of them are camping and some of them aren't, right?
Possibly, and I think at this stage they don't know the full amount of people that would be arriving. Obviously, some of that's contingent on ticket sales, and the same is true of how many people would be camping on site.
They've done this before, and a lot of the people come back, I think, for. Is this the same setup as last year?
This is the same site plan as the previous 2 years.
So there haven't been any alterations? No?
Nope, not to date. The applicant's submitted materials indicate that the site itself will have 45 toilets, 7 of which will be ADA compliant. They will have 14 hand washing facilities, water supply areas scattered throughout the site itself, food service located within the primary event area, and solid waste collection sites again scattered throughout the facility. As in the previous 2 years, the applicant is requesting a waiver from the requirements to maintain an ambulance on site for the duration of the festival. And this is in association with the hiring of Adventure Medics, which is an event medical service that's intended to provide medical care throughout the duration of the festival. The Bend Fire Chief has noted this in previous years as well as this year, and has accepted the establishment of Adventure Medics as a suitable way to provide those medical cares on site, provided that they have authorized personnel that know how to operate an automated defibrillator. In terms of security and traffic control for the site itself, the applicant has contracted with Dark Eden Incorporated, which is a private event security firm. They would have a minimum of at least 6 persons on site throughout the festival to provide crowd control and traffic control, with additional staff on call to meet the minimum standards based on the number of people on site at any given time.
So I read that they have 1 security person per 100 people, so.
That's the minimum requirement.
So that, if they have 3,000 people, that's 30 security people.
Roughly, yes.
So what's the on-call need, what's?
So the idea is at some portions during the event, there wouldn't be the maximum 3,000 amount on site, and so they have the bare minimum of 6 that will always be there, as well as once the population swells throughout the day during certain portions of the festival. I believe the idea is to bring people on when they need them and then send them away when they don't.
I don't know if this is for you or the applicant, but are they wearing some particular clothing or like vests or?
I believe they'll be identified with uniforms.
Uniforms, okay.
This is a close-up view of the main event area on site. You can see the stage where it would be roughly established, as well as the side stage, which hosts the late night events starting at 10 p.m. To 2 a.m. the following morning. You can see references to where the first aid station would be located, solid waste and recycling areas, as well as some of the restrooms that would be scattered within this general event area. And now, if the board has any additional questions.
I have a question. It
Sure.
Said in the rules that campfires, bonfires, and other recreational open burning are prohibited.
That's correct.
So does that mean people can't barbecue at their trailer?
I think that's the understanding, yes.
Right, they're not allowed to.
Correct.
Okay, they're only supposed to either eat cold food or buy food at the vendors.
And I believe you could have something like a propane grill as well. For example, if you had an RV, you could obviously, some of them have little outdoor
You
containers.
could have a propane grill?
I believe so.
Okay.
In the exhibits we were given, there's I guess it's Exhibit 6, there was a map that I don't think you've shown. It has a legend on it, and I'm not sure I follow what the legend, how it relates to what I'm looking at. Do you know what I'm talking about? It shows a neighbor buffer, but I don't know what that means, and
I think that was just another general aerial view of the property in question itself. And in previous years, some surrounding neighbors have referenced impacts from noise specifically associated with the event. And that was intended to provide one of those neighbors and show a general noise buffer distance.
And I think of a buffer as something physical. What is the buffer?
I think it's just associated with the distance between the actual stage itself, which is where the primary amplified music would be located, as well as the location of their house. So it's just a locational buffer.
Questions before we get into testimony? We might have some other questions. Do you have any questions, Commissioner Dare?
Oh, I did have a question. Now, the trash doesn't have to be hauled away until Wednesday, the 24th? That's the final day?
The 22nd is when they hope to finish cleanup of the site specifically, but the 24th, yes, is the final day they have to move things off-site.
Okay, but that's not given in the dates of the event then?
It
That's
is
just an additional add-on?
correct, yeah.
Okay.
Couple other things, I guess. One was that, the length of time for setup starts the Sunday before on the 13th, or maybe before that, whatever day that is, and goes to the 22nd. Is that the same length of time as last year? Seems like it's longer, but.
It is roughly. It's approximately a week before. The only thing that's been included in this particular permit that's slightly different from last year's is the applicant wanted to be clear that they would need access to the site prior to any actual site preparation, such as the construction of the stage occurring. So staff's understanding is that certain materials are shipped to this property, such as the materials for the stage itself, and they need a place to store those prior to being allowed onto the site to actually start the construction.
And then we received one letter from an attorney for the property, I think it's south of here. Pat Pays. And one of the question they asked about was, or not really question, one of their concerns is fire danger. That's something we've talked about in a lot of different contexts here. I don't know what the risk there is, but has there been any particular special thought given to that in terms of, I think they make the statement about there's not sufficient planning, or because there's not good enough access out. I mean, what thought was given to that, or?
So generally, they're required to coordinate with, in this particular permit, the Bend Fire Department to make sure fire access is sufficient for the site, as well as providing access to an irrigation pond on the property for fire suppression activities. If the pond itself is below a certain level, which is about half, is the standard they submit up to a week before the event, they're required to bring in an actual water storage tank to provide that suppression material.
Is there, I noticed there was something about the fire chief said okay, but the fire marshal didn't weigh in or something. Is that significant, or?
I think it's ultimately the fire marshal in this case either did not receive the notice with enough time to provide additional comments. But typically in these cases, they would defer, I believe, to the Bend Fire Department to provide those mitigation measures.
Okay. All right, anything further right now? Anything else, Commissioner Dare?
No.
Tom, anything? Okay. All right, so I think we'll start with the testimony. Start with the applicant and the applicant's attorney. Thanks for joining us today. Stacy Koft and Steve Holtberg.
Good morning, Chair Henderson, Commissioners. My name is Steve Holtberg. I'm the attorney for the applicant Four Peaks Presents. I'm here with Stacy Koff. We've been in front of you, many of you, for several years. Commissioner DeBone, for I don't know how many years now have you seen this permit before you? And I believe Commissioner O'Dara, this might be your first time that
It is. That's
you've
my
seen
first.
this one. But as staff mentioned, there really have not been any significant changes from years past on this site. Commissioner Henderson, while I'm thinking of it, the buffer that you mentioned was put in place, I believe, last year was the first year?
2 years ago.
2 years ago.
By us.
And that was just to create some additional space between a camping area and a neighboring property owner. So that was just put in there as an accommodation. It's not required by the permit or any regulations. It was just put in as an accommodation.
Yeah, okay.
This kind of permit, an outdoor mass gathering, is a little bit unique in both county regulations and state law. It's, as you know, not a land use decision. It's not a permit. And really the only thing that the county has to consider is whether the applicant can or has or can comply with the health and safety standards applied by the Oregon Health Authority and then as implemented through your code. That's really all we're here for today. And with that, I'm going to turn it over to Stacy to chat a little bit about the event, and then we're happy to take certainly any questions that you may have.
Okay, thank you.
Thank you. Hi, and nice to meet you, Patty.
Thank you.
There's a lot to address that I've already heard, and I don't know if there's a place you'd like me to start, or I could just go right in to address really quick what you had just said about, Phil, about the water suppression or fire suppression. We do have an irrigation pond on site if needed, and there are access roads that are adequate to get a fire truck through there, as well as we've contracted with Avion Water, and they have a water truck that drives around all weekend long to water down the roads and make sure that's good there. So we have that on site. Steve mentioned the buffer, and
Ask, follow up since you
Sure.
brought up first. Last year I think we were talking about additional security or making sure that was in place. I think fires are on our minds because of the big fires in California, particularly last year, and where whole communities burned and everything. And we're very concerned with it. So to have a neighboring landowner that has forested area bring it up is concerning. I guess, have you thought? I mean, is there other people or things you'd keep on the grounds that would control I guess what could start would be a grass fire probably, I guess it would go through, and I'm not sure exactly how a fire would get started, or maybe somebody out off property would start but we talk about this a lot now, and we're spending a lot of our efforts on making sure the area is safe, and so
There are a couple of things that I can jump into. The first would be the establishment of the drive aisles and fire lines, and you can see it from the map when you see it when you're actually there. It's very clear. Everything is marked off before people come in to see where the fire lanes are, and they're marked very clearly, and then cars park accordingly, so they're outside of the established fire lanes. The second piece is, and I don't even think it's part of the permit, but there's a water truck that goes by pretty much throughout the day and keeps both dust down and keeps basically the perimeter area and then internal drive aisles wet with water. So that's another component of the fire prevention, as well as obviously the irrigation pond, and should that go below that halfway level, there would be additional water trucks on site for that.
we also irrigate right up until the event, till we start erecting structures. They irrigate pretty much daily, or however their
Is
irrigation.
it grass then? Are you
There's
saying-
some grass. Most of the drive, the fire lanes are dirt. But where there is grass, it's pretty wet and well watered. And like we just mentioned, there's no flame, there's no open flame allowed. And everybody's really good at adhering to that. Small propane stoves or inside an RV are the exception.
Is smoking allowed at people's tents and campsites?
No, no, technically, but you can't really prevent somebody from lighting a cigarette in their own campsite. But we also have a very good track record of having a no waste event, and so if there are people smoking cigarettes, there's cans and places for butts, and we sweep the property as of Monday. I think you mentioned garbage next Wednesday, but the trash company comes Monday, and we're clear of all debris, and there's really not even a little micro trash left. We also work with the Environmental Center to create that zero waste event, and so our trash bill has been really low the last several years, and everybody has reusable cups. I know that's a different subject, but for the trash cleanup crew to not find cigarette butts is pretty great, because we know we're returning the land the way we found it, a week or two prior, and there's cows that live on the property as well, so we're pretty cognizant of that. I did want to mention, I have the staff report, and then I looked at the permit as well. The silent disco that's been going on for, I think we're going on year 7 or 8 with that. It's proposed from 12 to 2, but it is 1,000 feet from the neighboring property. So I know that was one concern in there, and that is done at 2 a.m. or 1:50.
It ends at 2 a.m.
And then the restriction is that you can't have events within 1,000 feet, and they've placed the tent where this occurs more than 1,000 feet from any residence. And for those who have not heard about a silent disco, perhaps Commissioner Adair, what that is people literally have headphones on.
I read that.
Okay, I wasn't sure if you
Oh, no.
were aware of what that is.
I read the details. I'm like, oh,
It's pretty hilarious.
I'll bet it is.
It's
sounds
hilarious.
like fun. Not good for your ears, but oh well.
There's a volume button on that.
No, I know.
But yes. So we opted 2 years ago to move our stages. So 3 years ago, the 2 stages were swapped. So the tent was closer to that property line in the main stage. The outdoor stage was towards the Stevenson properties. So we swapped them to just be on for good faith. I don't think that was required, but now the main tent area for the late night is 1,000 feet or more from the neighbors.
Okay.
Any other immediate questions? I could go on and on about the event itself, and 13 years in the making, and we've never had any issues. And I think medically, with the fire department waiving the ambulance on site, Adventure Medics has worked with us, and we've worked really well with them. And I think in the 13 years we've been doing this, we've had a sprained ankle and some Band-Aids and earplugs given out. So I think it's adequate to have them. They're on site 24/7, and there's a medic and an EMT on call 24 hours a day.
I remember hearing a couple years ago about I don't know, not a medical, but where somebody, I don't know if they overdosed or whatever, they ended up in a ditch or something. Have you had any other problems really, or health-wise, or in recent years, the last couple of years?
No, I recall that it was 2 or 3 years ago, and it was somebody that had, had a little too much, and actually our security team escorted her, took her purse and her, and bought her a taxi ride home, and she was fine. That's really the only incident, but that was 3 years ago. And the property had changed, by the way. So just the fence line a little bit, I think where that occurred had changed anyway last year, but there's been no modifications to the permit or the site since 2018.
How many children actually attend? Do you have any kind of approximation?
We do. I think last year, I know in 2018, I think there were 450 to 500 under 10, and less last year. So last year, I believe there were probably only a few hundred.
Okay, and you do, alcohol can be sold there as long as it's licensed, but you are not allowed to bring in your own.
Right. Correct.
That's a rule.
We have a pretty rigorous security team at the gates, actually.
Okay, really?
Yes.
They search.
That's our complaints.
They search every vehicle going through.
Yes, they
I've had mine searched every time that I go in there.
Well, I'm glad to hear that.
Yeah.
Yes, we've gotten some complaints of people's
Privacy is.
yes, stash being taken. And, you know, the permit is up to 3,000 people, but we've never sold that many tickets. Sadly for me, because I try to have it obviously be lucrative, but it's more of, because of the 3,000 cap includes all of those kids and vendors and band members, we have never sold even close to that. So
It does say you have a plus 10%.
Right.
On it, so you could go up to
For the buffer.
32.99 or something.
Which is good if, you know, we have that many kids under 10 on site, it helps that, but we've really never had to worry about that. And, you know, we know just from our numbers, we can calculate them online every day because they all run through a certain website.
Thank you.
Questions?
No questions.
So I think bring it up every year and as we talk about it. It seems like, you know, there's still, because I know I've heard from a couple of the neighboring property owners that there's still some, you know, it doesn't necessarily get support from everybody around it. And I've always wondered why you didn't move it to a little different part of the ranch or move it over or down towards the road a little more. Have you given any more thought to that, or is that physically wouldn't work, or? 'Cause
Right.
It seems like it would take it away. Even looking at today, some of this camping is pretty close to some of these houses, at least from what it looks like. I'm not sure which house is which, but on this map here.
Yeah, we've thought about it. We've mapped it out a couple different ways. And this still does make the most sense for safety, for access, for the topography, for rocks, for obstacles in the way for patrons. And some of those property or the houses you're seeing on the map do belong to the Stevensons. So that's, they come and actually come for the weekend. They have a huge family, I guess, to come from all over. So those houses are part of the Stevenson Ranch property. And then the neighboring properties, like we said, we've given a buffer that wasn't required by the permit, but that we think is fair to move farther away from them. And then I think to the south, there's so much brush in that way anyway, in the way, you know, from the south, from our property to the next, that there's no way to put the festival on that part of the property anyway. And then
Move it further south or move it further
south,
north?
well,
Move it-
north becomes the road.
Yeah.
Not road. There's just brush, like between the
So
pond.
the land actually goes back past this map, deeper.
No, I believe you have the whole property map. So yes, we did think about that, but we also, for ease of and safety for the patrons and the entire community and set up and tear down, since there's a 10-day window to do this, we didn't want to make any modifications from last year and the year before, essentially, because it worked so well where we had it.
And maybe you can tell me about the gray line.
Oh, yeah.
What is that? What is that?
I think, I don't see the map, I don't have it with me, but because I know it so well, that is a road. It also is, we gave a huge buffer to it because I think that's north to south, that's the
You
pipeline.
can look at this.
I think I know, oh, thank you. Okay.
But it doesn't look like the road where I think the access is, but maybe.
That is a road people drive on because there's a road, so the road goes across the whole perimeter if you basically draw a circle. And all the red lines are all of the roads and the fire lanes. So those are all more than 30 feet wide, I believe. The gray line is another road. We call it I can't remember what we named it. We named all our roads last year. That's also we used to call it the pipeline road because the pipeline runs on part of that as well. And if you recall in the last, I think 2 years ago, when there was some questions about it, we've gotten letters from the actual Trans-Canadian Pipeline Company that it's fine to do anything on. I mean, if you're driving on a freeway from California, you're driving over it. So that's a non-issue. We used to have it be 100 feet of a buffer, which we only need 20. So if we ever do get the numbers that we would like to get, and there's over 2,000 people on site, you know, obviously we could make that smaller. But right now we just have it as a huge road where people also walk on it. People there's lots that is done on it just because it's that large.
Natural gas pipeline. Thank you.
So I guess, yeah, the other thought I have about fire, I guess, was, you know, just having some kind of equipment on site. I know you're close to the fire station by the country club, but
It's 2 miles.
yeah, and that's where the ambulance is. And so, anyway, any comments or questions, Commissioner Dare?
So do you have like fire extinguishers there?
Yes.
You do? How many? I mean,
I
every
believe we
corner?
have 5 or 6, so we're required, on the stages, backstage area, medical area, one near the medical tent, which is also security. So yes, at least 4 or 5. And then we've also gotten people that have RVs that have them in them to just.
Right. That's one of the things you're supposed to have in your vehicle.
Right.
Is a fire extinguisher.
Right. So there's plenty in the campground.
Okay, just was wondering.
Okay, anything further? Okay, thank you.
Thank you.
Thank you.
So, then we have, and if anybody else wants to testify today, there's some blue forms up here to fill out. We have Kathy and Steve Miner. You want to come up and join us? See, it's afternoon. Good afternoon.
Good afternoon.
If you want to just give your name for the record and.
My name is Kathy Miner. Do you want me to go first?
Yeah, why don't you go ahead first.
Thank you for letting us come and provide some testimony. Since Commissioner Adair is new, I just want to give you a slight introduction to who we are. We live on the 5 acres directly southeast of the Stevenson's Ranch. We're on Heidi Lane, the road that's directly next to the property. We are less than 1,000 feet from the main stage. We purchased our property 10 years ago with the intention of raising our 4 children in an agricultural environment. I grew up on a large ranch where we raised cattle and hay. We had 150 acres in hay and 50 acres in livestock. On our ranch, we can have anywhere from 50 animals up to over 200 during breeding and hatching season. Before I get into more about what I was going to talk to you about, I just want to give a couple of my insights to what has already been presented. This past year, they did start setting up before the 13th, and this is what they're requesting, this additional time to drop off and stuff. It was very loud when the latrines were dropped off. They did actually set up a fencing area around their secure beer garden area, and that was all staked in with T-post, and the pounding and stuff happened prior to the setup date. And the 30 guards that you were talking about, that's for the entire weekend, all 3 shifts, day, evening, and night. So I do staffing, so that would be like 12 security guards for day shift, 12 for evening shift, and 6 for night shift. And they're proposing to have an event end at 2 in the morning. So you're talking 6 guards at 2 in the morning when all these people are getting out of an event for 3,000 people. 6 guards or 12 guards during the day or 12 guards in the evening. That's inadequate. The other thing about the.
Are you saying that's what the rule requires, or that's what they've done?
30 guards.
A day total is what is on.
I thought it was at the time. I
That's
thought it was
total.
at any given time, there has to be 30.
It's not at any given time, it's total.
Oh.
That's their minimum. The other thing about the fire being an issue, I have video from 2 years ago of a bunch of teenagers and younger children at a campsite where there was a propane stove. There was the awning from the camper over the top of the stove. There was no parent in sight, and they were grilling bagels and burning them and throwing them on the ground. No parents anywhere in sight, and I have a video of that. So yeah, I think fire is an issue. And regarding the trash, after the event last year, in the front corner of the property by where our mailbox is, there were beer bottles and signage left over from the event. And we did present multiple pictures to you last year of empty alcohol containers. And I heard Stacy and security guards talking about empty beer bottles tossed on the ground and asking people to come and pick them up. So I don't know how good the security is at the gate screening for alcohol at the event. Okay, so back to what I wanted to come talk to you guys about. So our girls, with our intent to have an agricultural environment for our kids, our girls have represented Deschutes County at the state fair for the past 7 years. They've brought home multiple Oregon state championship for showmanship. They brought home multiple conformation championships for their animals. They're very serious about their breeding programs. They sell rabbits for $80 a rabbit. They sell chickens for $120. They sell dogs for $2,000 a puppy. So they're very accomplished agricultural women. It's not, our farm is not just a little hobby farm, it is a working farm. And the venue of the Four Peaks Present, put on by Stevenson Ranch, has impacted our strictly agriculturally zoned property. Our animals do not eat or drink well during this time. They've lost weight. There's been several times where our girls' animals, and these are state championship animals, have not made market weight because of the impact of the noise during their growing season. And for a trio of rabbits, I've seen some of you at the auction, you know that a trio of rabbits goes for $1,500. So that's $1,500 multiple times that my girls have not been able to make because they're rabbits. And the same breeding pairs make weight in that time, did not make weight because of the concert. Our turkeys have rubbed their paste and rubbed their feathers raw on the fence and haven't been able to be taken to fair because of the damage. And even, did you know, even the cattle on the property have to be removed from the property because the ranch can't function as an agricultural function with the concert there. And while the ranch is truly 150 acres, only 75 acres is permitted for this event. So you're talking about all the stages, all the camping, all the parking, all the vendors, all the children events on that 75 acres. And they're already spilling over beyond that 75 acres down below the main barn on the event center. So when you ask them why don't they move over further, they've already utilized the entire 75 acres and they don't have a permit for the other 75 acres. The event is close to the fence line on the east and the west side, and the south side of the property. The property is just truly not large enough to host this event. Personally, not agriculturally, I'm a nurse at the hospital and I work night shift. This is a weekend I work. It's very hard for me to sleep or relax this past year. I had a very stressful time. I had to help a family deal with death, and I brought a letter from the family thanking me for, it was 4 days that this occurred over, and I was unable to get rest. I had to go and stay at a hotel, so I wasn't able to help my family during this event. It's a very stressful time. In the past 3 years, we've been told that it's the law, like the attorney was saying, that you only have to consider if the event is safe and that the permits are checked off. So the event has been permitted, but there are other laws in place that need to be considered, the laws that have been written for the utilization of the property. Which law is more important? It is, and during the past years, during the permit, not you, Commissioner Adair, because you haven't been here, but the other commissioners have all said that it's very unfortunate, the event, the impact on the animals, and that if you were the neighbor that you went host this event, that you felt it was not a correct event for this property as well. I would like you to ask to vote not for the easy vote, but vote to support the laws that state what the intent of the property is for. This property is zoned for agricultural, it's not zoned for entertainment. So this event directly impacts the intent of our property, and it impacts the works and the goals and the hopes and the dreams of our farm for the entire year and for the other neighbors' farm in the community. So we ask that you deny this permit.
Thank you. Any questions?
Thank you very much for your testimony. I know we've been here for many years, and I mean, the guidance up front isn't a denial, it's making it appropriate to the law. So, I mean, there's a disconnect here with, the approval process. I mean, I do feel bad, and I understand the testimony, and, thanks for joining us. There's history in the state of Oregon about, okay, we have EFU lands, and the state legislature defined this process around the state for people to do these events. So, we have a disconnect with your intentions, and I think we're...
And I think that some of the intentions of mass gathering permit is for the freedom of speech. This is for entertainment and for profit. I don't think it's the true intent of the original law is to have a mass gathering for entertainment.
Thank you.
I had a question about, she raised issue of the permit only covers 75 of the 150 acres. Is there a reason for that, or is that all it's applied for? Or?
It's the limitations associated with the actual outdoor mass gathering permit itself, and so in this particular case, the applicant has requested the eastern 75 acres of this total 150 acre property be associated with the event.
That's all that you can do with a mass gathering is 75 acres, or?
Under this particular proposal.
Is that based on the number of people, or why is it limited, I guess is what I'm wondering.
It's just the language within the Deschutes County Code for these outdoor mass gathering permits.
So if you have more land, can you do more land? If there's a 1,000-acre parcel, can you do half of it, or do you still have only 75 acres?
I'm not sure off the top of my head, Commissioner, but I believe it's limited just as a firm amount. But I can certainly get back to you and answer that question.
I would like that question answered too, because I'm thinking like, okay, what if they do go somewhere where it's 1,000? How big was Tumalo historically? Do you know that document? How big was the Tumalo site? Do you remember, Commissioner DeBonne?
Not the parcel size.
What? Oh, sorry. Okay. All right.
Okay. Mr. Miner?
Good afternoon, Commissioners. Steve Miner. I'm going to try and keep my comments a little briefer than in past years. I just ask that you consider the testimony that we gave and evidence that we gave in past years, because much of it still applies to our concerns about this year. Let me start first by addressing a couple things that have come up in the discussion so far. I think the testimony on outdoor cooking is still very unclear, use of fire. The first year, we were under the impression that there was to be no outdoor fire at all, of any kind. As we've been on the property and observed outdoor fire in use in barbecues, and we've even seen candles in use in a couple of areas in the event site. I'd like to see that addressed. That's definitely a big concern. We're not always downwind, but we're usually downwind, and we do have a grove of trees there. That would be a terrible thing to have happen as well for event attendees. Let's see, smoking. whether smoking is permitted or not. We've observed many people smoking both cigarettes and marijuana on the event site, even around kids. Silent disco seems fun. The music has never been a problem with the silent disco. We do have audience participation noise from the silent disco. So there's cheering that goes on, and there's excitement when they come out of the disco and leave and things. So we do still hear it, not always, but on occasion. The incident with woman, it was a little different than I think has been described so far. There's a woman that left the property and ended up in a ditch on her neighbor's property. She had been using acid, and the neighbor's security team she saw this and got to her and got her out of the water and helped her back into the event site. Beyond that, we're not sure what exactly happened. The issue with outside alcohol, we gave a number of images of evidence of outside alcohol at the site. I also testified last time about being able to drive in with outside alcohol in my vehicle and not have it found or searched or confiscated, not being turned away. I do also, I'm curious, obviously I would prefer them to find a more appropriate location. I don't think this is a great location for the event. But I'm curious to know why they don't consider using the airstrip and surrounding fields, which are west of the current location. It's flat, it's open, it's very well irrigated grassland, and could be a perfectly good location for the event. And there's plenty of access from the driving point and safety point, so I don't see that as a hindrance. So there'll be a little bit of duplication, sorry, but our home is, we believe, one of the most affected properties that border the east and south sides of the event site. I work at home. I'm a software guy, technology guy, and I have a home office there. It's difficult to work and concentrate during the event with the music. Kathy, as she mentioned, is an RN. She works night shift, 12-hour shifts. Our girls, 16 and 19, as Kathy mentioned, are actively participating in 4-H and FFA, all the way to the state and national level in leadership roles. They raise animals for competition and profit. The population includes lots of animals, as has been testified already. They make a significant investment of their own time and money, countless hours of chores, study, travel, service, and financial responsibility related to that activity. We can't offer that experience to them without acreage zoned appropriately. That's why we chose 11 years ago to move to this property. We can't just pick up and relocate 150 animals to suit the needs of the event. That's not practical.
Could I ask you a question? Do you
Sure.
know what does Google say the distance is from, you said your house to the stage?
Yeah, it's a little under 1,000 feet. I don't recall off the top of my head.
Okay, but it is under 1,000.
Yeah, we did have that in the testimony in the first 2 years. So we're not opposed to the event. I'm a musician. I love music. We're opposed to the location. I'd like to share a couple of experiences from this last year. So the 2 weekends that the event spanned set up to the actual event included our daughter's 16th birthday, our son's college graduation, and Father's Day. We were unable to use our property for these occasions due to the festival. Not practical. As Kathy mentioned, she's night shift. She was working Thursday, Friday, Saturday, and Sunday of that event. She needed to sleep during the day on Wednesday, Thursday, Friday, Saturday, Sunday, and part of Monday. Not possible. She had to sleep at a hotel. We did have an unexpected, unwelcome encounter with Four Peaks this particular year. We have several very friendly, well-behaved dogs in our household. They enjoy and need to be outside. They roam freely on our property and reliably stay close by. But the event creates an attractive nuisance for our dogs. They like people, they like food. During the event, we're forced to keep them in the house or restrain in a dog run. The dogs are unhappy and imposes additional burden on people caring for the dogs and using the house, not to let them out accidentally. That's their normal behavior. We had a moment of panic this year when it seemed like one of our dogs had gotten loose. This was during the setup time of the event. We feared that she had entered the festival grounds, and Kathy searched the dog along the fence and into the parking area of the event. Turned out that the dog was not loose. It was safely inside our house. And a short time later, we had an officer from the Deschutes County Sheriff's come visit our home, and we were told that we were in violation of allowing our dogs to enter the property, and that should it happen again, we would be fined both per occurrence and per dog at a very high rate. The truth, no dogs were on the festival grounds at the time, and photos were never produced. They said they were told there were photos. It felt like harassment to us, so it was not a comfortable experience. Don't want to spend a lot of time on this, but we've been told that aside from considering to litigate against the event and the landowner, that our best interest is to document violations of the permit process to help encourage them to find another location. We've used a drone to do that. We've used cameras. In the past, I've been accused of using a drone improperly over their property. I want to assure you that I haven't. I've been compliant with the rules. I've included use of AOPA's legal services to make sure that I'm doing that. I use automated flight software to control the position. I do not fly over the event. I fly over the perimeter of the event for which property to which I've obtained permission to do so. But this year, I just wanted to point out, because it may come up later, I observed 2 other drones in the area. One was being operated from the festival grounds, and another flew over my property during the festival and over the event during the festival. It's not me. I don't know who it was, but I think it was somebody east of our home. At the same time, both are operating in violation of the law by operating over an assembly of people, right? You cannot do that without a Part 107 rating and a waiver, which very few people in the U.S. have managed to achieve that waiver. So flying over the assembly of people while it's going is not allowed. Noise is really one of our biggest complaints. It affects many of our animals in negative ways. We observed animals refusing to eat and drink. We documented weight loss in animals destined for the fair. It creates anxiety in the dogs, including barking. It affects our ability to sleep. It affects our ability to work out of our home. It affects our ability to entertain and recreate at our home. I spent the morning with a professional sound engineer hoping to bring sound to demonstrate what 70 dB and the difference between A scale and C scale measurement is really all about. It's very hard when you look at that number on paper to understand what that means. You can't feel the sound going through your body. You can't see glasses of water in your home vibrating. We determined that it would not be easily appropriate to create a good demonstration that would accurately represent fairly what that's like here. So they would like to offer, and I would like to offer to the commissioners to join me and a professional at a time in the next week or two at a situation where we can present that to you, just so you can understand what that's really like for us living there. This year we continue to have vehicles using our driveway, people that were Uber, Lyft, taxis coming up our private driveway in the day and the middle of the night. We didn't have any, in the past we've had people cross our fence line to take advantage of that. This year I didn't observe any of that. I think it was more mistakes by Uber drivers coming up, but I'm not, we weren't watching that the full period of time. We did have trash, we did have dust. I am a little concerned about the site preparation before the 13th. I think that extends the length of the overall experience to more than almost 3 weeks. I don't think that's necessary. I think they can get their work done in a similar time frame they've done in the past. Again, like many, if it's going to be permitted at the same location, I think they could move it substantially to the west. I think that would help a lot of the neighbors. you may or may not be aware, but the festival has already encouraged more than one family to move away from the area, including a 25-year resident that didn't want to move but couldn't tolerate disruption. And I wanted to express a little anger about a statement in the application in response to item 816-190, claiming 12 years of operation with no county code violations and demonstration that it meets or exceeds all standards. If this is true, it's only true because county enforcement has not done an adequate job monitoring the event or following up on legitimate complaints with documented evidence of violations in numerous elements of their permits. We have provided clear evidence of violations in 2017 and 2018 already. These include noise violations, alcohol violations, drug use violations, open fire, and security problems. We've spoken to neighbors of the previous festival site and have spoken to numerous law enforcement personnel about the history of the festival. We've heard the complaints and problems have been a regular part of the festival's history, and yet they seem to never result in code enforcement. That's an incredibly frustrating thing. I don't know where the breakdown is there, but it's like if we're going to have permit and have boundaries on what they're allowed to do, and they violate it and nothing happens, then what's the point? In past hearings, the applicant supporters of the event. Oh, yeah. So I'm going to ask for a favor. So in the past, the applicant and supporters get, by the way the hearing is designed, they get to respond to our statement in the public hearing. And in the past, we've had untrue accusations made about us in public. We would appreciate the commissioners offering us an opportunity to respond to that during the hearing if that comes up. So, in summary, there are many clear permit violations in 2017, 2018, 2019. I don't think it's the right place for the event. The event hasn't been managed and secured permit requirements. I believe there are established venues that the county has designated that are well suited for an event of this nature, which would overcome these issues. And we respectfully ask that the permit be denied.
Okay. Thank you for your testimony. Any questions, comments?
Thank you.
I asked my questions.
Let's see. Oh, I know. I was going to ask you about, are you the neighbor that the buffer was created? Have you discussed?
Yes.
Are you aware of the buffer and what that is?
Yeah, exactly aware. So the very first year, the campers came very, very close to our driveway. And I think closer than was originally intended. I just think of the setup event. And the noise and interaction between the campers and our property was a challenge. We had people reaching out. In the next year, they changed the layout, they moved it back, they didn't move it back quite as much as I think they planned, and then the third year they moved it back a little farther. That has helped with some of the noise issues with the campers.
How far is it from your fence line or whatever?
That's a great question. I don't recall off the top of my head.
But it is just, they put in some T-post and a rope just to keep people from camping out of that area. There's no sound barrier and things, it's just a distance that prevents people from camping right on our fence. Because the first year they had people putting their hands through the fence and petting our dogs.
Doing what? Oh, petting your
Petting
dogs.
dogs.
And I know that since we've had this hearing a couple of, I guess 3 other times, there were some comments that by other neighbors are you in communication with the other neighbors about? So are some of your complaints based on what they've told you also, or you did your complaints?
Most of the things we're bringing are based on what we've observed personally. One of our neighbors is reluctant to testify, partly because of what they do on their property. They don't need outside attention. Another neighbor has a challenge with the landowner and is very opposed, but doesn't want to testify because it will impact their relationship. And then other neighbors have been vocal, but they're frustrated because they feel like they're not being heard.
Okay. All right. Well, thank you for your testimony today. If there's anybody else that wants to testify We've need one of the blue forms. Is there anyone else that wants to? So is this time for the applicant to?
It's time for the applicant to provide rebuttal comments.
Okay. Any comments or? Dave, is it required that we make a decision today?
No, not today. No need on that.
Thank you.
Good afternoon again, Commissioners. Probably just a few comments in response. One, I think there was some confusion about the property size and a limitation. Stacy can correct me if I'm wrong, but I believe that they only have access to that half of the property, correct?
Correct. The property, I think, is a total of 240 acres, so we don't utilize even half of that due to, again, the topography, the restrictions that we put on ourselves and buffers and the Stevenson Ranch Family Trust or just the family members. You know, we don't go too close to their houses as well, so the whole west is not utilized.
That's not it's not a county restriction or a state restriction. That's just what's been made available for the property.
By the landowner.
Mm-hmm. And they would allow us to use more, but we haven't needed it.
Any other comments or?
In reference to violations that the minors speak of, there's been no formal violations. The code enforcers come out every year before the event, usually during the event, and I talk to them. They walk around the property freely. And this year there was a discrepancy, and so I got called away from probably one of the most important moments of setup. And I came in here, actually we came to the planning building across the street and met with at least 5 of the community development personnel and cleared it right up. It was national fencing, if I want to get in, if we get into details, and I could tell you exactly what happened. National fencing had come and dropped all of the fencing off that we were going to be set to secure the perimeter and the venue with on the Saturday before, the day the permit started. I don't know if it was the 12th or 13th of last year. And national fencing came to drop everything off the day before. So we cleared that right up, and it was a non-issue, and it wasn't a violation on our part. I think whatever, this is all so loaded.
I think it bears restating, though, is that code enforcement and to the certain extent the sheriff too, they're available to come on the site 24/7. It's not as if it's a closed site. So code enforcement has been there, the sheriff has been there, and still no code violations have been given.
So you said there was a change on the application, I don't know who wants to add, but with regard to dropping stuff off before the 13th, is that?
That's what I was just, sorry.
Well, and that's what you're addressing, is that, and how much before the 13th can things be dropped off?
They don't get dropped off. So before the 13th, what we're talking about this year is are a couple of the people that we have working on the ranch, and even the Stevensons themselves and the ranch hands that they have work diligently for us to irrigate, remove rocks, and so some of my team comes and helps them to suppress things, you know, like irrigation for fire suppression, removal of rocks for obstacles for patrons. So it's clear, it's simply just that. It's not erecting anything, it's not rental equipment. There are some porta potties that are dropped off so that the workers prior to the 13th could have a place and not soil the property per se. So we do have a couple porta potties there.
But not 45 of them?
No, I think there were 2.
That's one of the things that, this is apparently the law in Oregon to allow events on farmland, and as you've heard there's a variety of neighbors here that are not happy about this specifically. I know the people that go enjoy it, but the longer it gets, the more probably it bothers people. I mean, I didn't remember it was always starting that many days before with setup, but I thought it was 3 or 4 days, but this is more like a week before, so.
Our setup, when we talk actual setup of erecting structures, is the Tuesday before. So it's not quite a week. And, this event, I think last year we sold 900 tickets. So this isn't a huge event that's got rowdy crowds, that's got trash everywhere, as I spoke to the zero waste before. This is a family-friendly, really mellow event. When you think about a lot of the other mass gatherings that are going on in the state, possibly in the county and in other neighboring states, it's, you know, as Steve said earlier, it's a matter of, did I meet all the approvals? Do I have a good track record? Have I showed good faith? And yes, from every angle. And I wouldn't sit up here and ask for this for the 13th year in a row if I thought I was violating anything or providing harm to anybody or not doing something that I truly have a passion for and believe in. And it's not a moneymaker. Huge. It's really not. Without even talking to her, sadly, because I get so busy, I got a text and I responded within 10 minutes, and Kathy Miner was put up in a hotel on my dollar for close to $1,000 for 4 days. So I do anything I can to appease neighbors and to invite them all. Several neighbors from neighboring properties and all the way to, I think, couple the roads, because I've extended it out. If somebody emails me and they get wind of it and they live 4 miles away, I welcome them. So I invite all the neighbors, and so far I've got nothing but positive feedback from all the neighbors, just most of them. And I haven't heard anything since we started on this property from some of the immediate neighboring properties. Maybe they have, and that's understandable, but we haven't received anything on public record or in my personal inbox for that.
So there was an offer for us to observe or experience a sound level something, and I think that's our county noise ordinance or and he asked specifically if he could respond after you, so I'm not sure how that's going to go. But any thoughts about what was offered there? I'm trying to digest that myself as an elected official and decision maker.
I can't offer the board what you should do about taking a sound test or participating in a sound test. What I can say is that the code has very strict limitations on what sound can be, how it's measured, where it's measured. I know that Stacy employs people that walk the boundary and do it, and I know that the sheriff has done the same thing over the years, and there have not been any noise violations.
So is this in context of sound level during the day, or just at 10 o'clock when it needs to be below a certain level, I guess? Can you put that in perspective for us?
Yes, we go out actually at sound check, so to make sure that the sound checks aren't too loud either, and then at 10 p.m. as well as midnight. So we go and check that. And sound is a tricky thing. I completely understand. And, noise violations, I also completely understand. And, sometimes in here, we've raised, with the microphone and our voices, we've been beyond 50 decibels, depending on, how far away we are from each other. So it's a tricky thing, but we really make sure to do our best. And I've run into the tent and behind the main stage several times to tell the engineers, hey, I want your reading, and then we go read it from other places on the property. We've been down towards the Will Call area, which is near Knott Road. There's definitely no noise down there. And so we really are diligent. I mean, I walked the property with even my father who's sitting here today. I remember at about sunset just to get a read on what it's like at that hour too. And we've not been in violation with the noise ordinance, but
So, yeah, just to share some experience, so we live by Quill Run Golf Course, and they've got a little tinny speaker for the next up on the tee or whatever. I can't hear that hardly ever, and all of a sudden it just sounds like it's close, just once in a while in the summertime. But also we have a concert in my neighborhood in southern Deschutes County, and there was a couple years ago at midnight on my front porch. I thought, man, do they have it going on, but I haven't heard it since. So my experience is, as a decision maker, it can be very different. Just the conditions, the atmosphere. I don't know exactly what it is, but and as I say, for that little tinny speaker at the golf course, I'm sure they don't turn it up and down. It's just you hear it sometimes. Just experience, just letting you know.
Okay. Any further comments or?
not unless you have questions.
I did, Commissioner Henderson, I did hear you ask if you needed to make a decision today. I would encourage the board to do so. It's only a matter of timing. We put the application in when?
September 1st.
September 1st. And each day that goes by, it just makes it more challenging because, as you know, we cannot advertise and we can't get firm commitments from bands as well until there's a permit in place. So the sooner we can have a decision on this would be appreciated.
Okay. Appreciate
Thank you.
that. I don't think it will take very long, so. Hello.
Hello, Commissioners. This is Cynthia Smith with the Planning Division, and I've worked on, I have quite a history working on Four Peaks Music Festival outdoor mass gathering permits, so I'm usually in the loop every year, regardless if I'm the one who's processing the permit. And I just, for Commissioner Adair's, and it may have said it in your staff report, that also covering the miners' comments, that the state, the zoning will always be exclusive farm use, but the state has this special carve-out for outdoor mass gatherings, specific for farmers to help generate income, and there is it's not treated like a land use application. It's hard, the approval is the route that they go in unless there's something really egregious that cannot be approved. I think Four Peaks has always represented a good track record, and they're always trying to improve their permits every year, including like buffers and like they've done for the miners. I do want to clarify a couple things. The percentage of the lot that they use, or the parcel, that is not in code. That is just something that was probably called out for their permit, and what the owner is willing to offer them to use for that of their land. So however many acres that is. So there's nothing in the code or state law that says they can only use up to 70% of the parcel size. So I just wanted to clarify that's not really a code or a law in place. Because I know Commissioner Adair was wondering, and a few of you others. And then also the security is one person per 100 in attendance at the time. So if their permit's for 3,000 people, but they only have, say, 600 on site, they should only need 6 security personnel, 1 per 100. So
As long as those 600 are there, so it's not per day, it's really.
it's what's on site at time. So it's, yeah, so I just wanted to clarify that, because the miners did make it sound like they needed 30 all weekend long, and it's really what's on the site at that time. And then regarding code enforcement and the sheriff and
So real quick, I mean, on the security, so if they had 3,000 people on site.
At one time.
And it was,
would
morning,
need
evening,
30
and
people
afternoon,
at that
they'd need 60 people to take a shift over or something. I mean, it could balloon too if
Yeah,
it was that
could,
successful.
And that's what they have to plan for.
Yeah.
So it's what's on site at the time. Last year, right before, or this last June, right before Four Peaks Festival was going to be underway, a group of us, including the fire department, sheriff's department, OLCC, planning staff, and code enforcement, we all met and how to manage this festival because of the history of complaints and whatnot. And so we had code enforcement staff go out there. They went out there in the evening for a couple nights. The sheriff went out. They were always doing sound tests when they were out, evaluating other things and other provisions that the permit. And the report back was there was no violation. The sheriff also had the same response. We reported this to Nick Lilac, and I don't know if he passed it on to the commissioners or Tom Anderson. I'm not sure, but that was, I just wanted to let you know that every agency is paying attention every year to monitor this festival and other festivals.
We got notifications as it was happening, maybe the next day through email or whatever, but we
Yeah,
got notified.
Yeah.
So does that mean someone was there at 2 a.m.?
They were there after, I have the email, I think it was after 10 at least, to monitor the sound level after the 10 o'clock hour. So we had 2 code enforcement go out for 2 nights in a row, Friday night and Saturday night, probably the busier and nights, measuring the sound level and walking the boundary and just monitoring in general. I believe OLCC probably had their staff out there. I know the sheriff's department had their staff out there as well throughout the.
Well, I have animals, And my horses, if the neighbors start shooting, I cannot believe it. My horses will leave their grain. They don't leave grain. And they'll all look out and, so I understand how this is, this isn't the normal thing. I mean, if that concert was there every day, after a while, they'd probably just kind of ignore it. But because it, comes in and then it leaves, they forget. So it's, it's, when you have an animal, it makes you very aware of noise.
The decibel level, is that, isn't one of the issues that the decibels is what kind of decibels is it? Like there's different ranges of, and is that a county ordinance or is that the state law?
It's actually in our, the county ordinance. I don't recall what the state ordinance, state law states or mentions. I know there's been work on trying to mirror our two language, but it just hasn't happened.
So the actual county ordinance in this particular case is sound levels in excess of 70 decibels prior to 10 p.m. and in excess of 50 decibels after 10 p.m. as measured upon the A scale of a standard sound level meter on the affected property.
On the A scale. Any further questions or, okay. I'd like to look at this stuff. Maybe we could finish it next week. Is that?
My thought is, let's make sure we set a specific meeting, or, I mean, not that it's required, but the expectation for the applicant for, let's not just say in the future if possible here.
Well, that's why I said next week.
You said next week.
Do we have Monday and Wednesday meetings?
I'm not going to be here from Monday.
We have Wednesday meeting.
Both. Yeah, we have.
You're not going to be here Monday, you mentioned.
I'll be here Monday.
But Phil won't be here on Monday.
Yeah.
So, can we set it up for Wednesday, maybe?
Yeah, I'd advocate for that, making sure.
Okay.
I think that's, and I don't know why it took 3 months to get to us, if the application was really dated September 1st. But, okay,
I don't
it's
know
like almost
that
December
either.
1st.
Yeah.
So, that's unfortunate, but it did take that long to get to us. And we'll have to look into that. Peter?
Yeah, thank you. Mr. Chairman, members of the commission, for the record, Peter Gutowski, Deschutes County Planning. I checked. It was submitted on September 10th, which is a Monday, and then it was assigned on the 17th. And so when you factor in, I mean, I'm not making excuses for our staff, but we need to send out prior notice. It's not reviewed as a land use decision, but we require signage, and notice goes out to neighboring property owners. So an application like this that requires a hearing, it's not uncommon to have something like this take around 60 days, 30 days for completeness, and then you're preparing the materials. So on the face of it, it seems long, maybe bureaucratic, but that's for the types of issues that we're dealing with on a regular basis, that's not uncommon.
Thank you.
Puts it in perspective. Well, it's good that there's a public notification process for this. I mean, we do support that.
Yeah, and I just, one more, that's something that's not required of us to do. We do it as a courtesy to surrounding property owners because we feel like they should understand what's going in right next to them. And then we also provide a notice of decision afterwards, which is not required, but we do that for the community.
It seems like last year it was earlier in the year that we did this, but.
Yeah, and it depends on the planner's workload and how we get everything in here.
Recollection, but.
I just remembered one last thing regarding fires and fire. You were talking about grills. A lot of those requirements come from the fire department. They do allow for propane grills, but yeah, outdoor burning is not permitted. The fire department
was not allowed.
Correct.
Circle, yeah.
Yeah, and they do come in. That we require them to come in and not only look at the roads, but look at the whole setup and the tents. And so the Stacy
fire marshal comes in, or
yeah, so somebody from the fire department will need to sign off so many days prior to the event happening.
So kind of, since we're all here still, so some of my thoughts, the water truck putting water on the roads would be different than a fire truck holding on to water, because it would be empty at some point. So if we're in that situation where the pond is less than 50%, I would expect to just know that one's a fire truck and one's a truck putting water down on the road. And then also the activity before date. Looks like, is this a new condition? The applicant shall have access to the site prior to June 13th to accommodate deliveries and site preparation.
That's correct.
Yeah, so that wasn't on there before. And my thought process was, if there was activity, that it wouldn't be too late. So the dates or the time is already set, 9 a.m. to 7 p.m. And in the summertime, 7 o'clock feels like 4 o'clock. I mean, you just know that, today at 5 o'clock is going to feel like 9 o'clock, but, so I think it's appropriate, if this is a working ranch, if there's activity, if somebody's coming in, putting something on the ground or setting something somewhere, and leaving, could be ranch operations, could be setting up for this. So I'm supportive of, activity outside of those dates, just for simple deliveries.
Right, thank you.
And so to be clear then, is the hearing closed and the record closed, and you're going to deliberate a week from Wednesday?
Yeah, that'd be correct.
Thank you, Cynthia.
Thank you.
Thank you. Thank you, Colleen.
What's one?
So I guess we don't get lunch today. Oh, well, it's Thanksgiving week. We didn't need lunch today.
Well, I've got a turkey sandwich up there from the turkey my wife.
Why would anyone have a turkey sandwich?
Thank you for coming and your patience today. Thank you.
Thank you.
Thank you.
Okay, we got staff. I'm gonna be in favor of a break. Maybe staff.
You do that second-
Maybe staff is hungry too.
Do that second reading.
Huh?
The second reading.
We don't want to have any more duck, do we?
Would you be okay to do the habitat plan after a little break? We could do the second reading of the, was it the floodplain
Yes.
amendment? And then we could take a break and do the habitat after that, because we're gonna have a gap there anyway. We're gonna do the, two health issues, but that won't take very long. Maybe we do the habitat after that, so. All right, so, do I just read the title?
Yeah, typically Tanya would,
Come up and,
on her way up to tee it up.
all right. good.
I'll go on record saying I'm always hungry. So, for the record, Tanya Saltzman, Associate Planner. I'm here to present ordinance number 2019-016, the model flood amendments, for consideration of second reading. As you may recall, Nicole Mardell initiated this process, but her last day was Friday, so I am picking up this project as well as a couple of others. The board held a public hearing for the model flood amendments on November 6th, at which time the board closed the oral and the written records and deliberated, voting to approve the amendments, and first reading was conducted that same day. It's been a little bit more than 14 days, and
Bless you. God bless you.
And so the board is scheduled to conduct the second reading of the ordinance today.
All right. So I just do a second reading?
You'd need a motion for second reading
Oh, okay.
by title only, and then a motion after that for adoption.
Okay. Seek a motion for second reading?
I move that we have the second reading of ordinance number 2019-016, model flood amendments,
By title only.
in title only.
I'll second that.
Any further discussion? Commissioner Dare?
Yes.
Commissioner DeBonne?
Yes.
And the chair votes yes. So now I read it right. So this is the second reading of ordinance number 2019-016, an ordinance amending Deschutes County Code, Title 18, Deschutes County Zoning, and Title 23, the Deschutes County Comprehensive Plan, to incorporate DLCD's 2014 Model Flood Ordinance language. Seek a motion approving that ordinance, right?
Motion moving adoption?
Moving adoption. Motion moving adoption.
I'll move adoption of ordinance number 2019-016, model flood amendments.
I'll second it.
Okay, further discussion? Commissioner DeBonne?
Yes.
Commissioner Dare?
Yes.
And chair votes yes.
you.
Good job.
Yeah, that was it for that one. You brought that one home.
Tanya.
Most successful they have ever done.
So I think we will adjourn for,
10 minutes.
30 minutes or 20?
Yeah, there's no rush, I
I
don't
mean, I don't think so. Are you guys all right with that?
Are we having 30
What's
minutes?
that? Okay.
Well,
So,
talk about 2:30 or 3, right?
well, we're doing, well, I think the health,
Janice is gonna be here at 1:30.
Oh, yeah, okay.
Send her an email and
Yeah.
then come later if you.
yeah, have her come at, how about 1:45?
That sounds excellent.
Yeah, then we have 45 minutes to do a couple of things.
Tell her 1:45. At least she'll get it.
Scratchy was.
Reconvene the Deschutes County Board of Commissioners meeting for Monday, November 25th, 2019. I think our next order of business, we're going to go back to a couple of items that were on the consent agenda, which is item number 1 and number 3. And Janice Garceau is going to join us, both health.
There's a page from her, I think.
This is-
of CBHC funding overview.
All right, so we'll start with the St. Charles Psychiatric Emergency Sageview contract.
Okay, good afternoon, Commissioners. As you know, that item was on the consent agenda. It's a renewal of our contract with St. Charles for their Sageview and PES services, and I'm here to talk about it if you have questions. I can give you a little bit of an overview of what that contract is for, why we have it, what it does, and what's new in the contract, if you would like me to do that first. Or if you have questions, I'll take.
I had a question.
Okay.
That's, it says on packet page 14 that all 3 counties agree to the regional approach. That's in principle number 2. And I'm wondering, what do Crook and Jefferson pay for this contract?
I can't remember the exact amounts, but it's under 20,000. So
each one of them?
Yeah, so what happens with this particular contract is their service element $24 pass through directly to us by agreement, because they have such a small amount, and then we do the regional contract.
Okay.
So we have a large amount of service element, $24, and they have a much smaller amount.
So 20,000 for the whole period then is what they pay?
Well, I would have to get the annual amount of service element dollars that would have come to them that go to, because it's just lumped into our overall amount.
Okay. I know, I was just trying to pull that out.
But it was pretty small.
Is it proportionate, though, to the populations? I mean, is ours 6 times more, or whatever the population difference is, 8 more, you know?
I think it is, these are Oregon Health Authority service element dollars, so they typically are based on a formula that includes population. The formula is a little more complicated because it also includes your civil commitment count, but that typically for population is very small in a county like Crook or Jefferson compared to Deschutes. So it's their caseload model for how they make up the formula for what funding counties get.
I have a question. Did you have another one, Commissioner Ayers? So there are 2 different facilities, right? Sageview and PES are different?
PES is a unit within the emergency department, and Sageview is the actual inpatient psychiatric facility that is managed here in Deschutes County by the hospital.
But it's a separate building,
It's a
isn't it?
separate building.
How many people can that take care of?
I believe it's 12 beds.
So a total is 17 beds between the 2? 12 and 5?
Yes, PES has 5 beds.
It's in here, but I couldn't find the one for the other, so it's 17 and 5. Okay. Or, did you say 17? No, you said 12. 12 and 5.
12 beds.
12 and 5.
And my interest, I also wanted to have it go over this just because I was curious, since we've talked so much about stabilization center and stuff. So, and what's the difference between the PES and the Sageview? Is one longer term?
Well, Sageview is an actual inpatient psychiatric facility that's a standalone. The PES unit is a place that people who present to the ED with a serious mental health disorder can be housed for a period of time. And sometimes the PES unit, that's the shorthand for it, but it is a place where people may be assessed for whether or not they need to go into Sageview. The other really unfortunate fact is that the PES unit is also often where youth are served, because we don't have a youth facility in Central Oregon or anywhere really in the region. And that's also who can often end up in the PES unit for an extended period of time until there's an appropriate placement found for them.
Oh, our packet, Ken actually needs to sign off on it, Ken Harms. His name is on it, but he hasn't signed off.
Okay.
So in theory, then, with regard to the stabilization center and the connection is that the transportation-ness between units possibly, I mean, it seems like someone that was first came to the stabilization center might end up at Sageview or might end up in PES unit or vice versa. They might show up at the emergency room and we would want transportation. Just seem, after going into all that study of all those, and it seems like that's going to be a component we're going to need to fund somehow, some kind of transport back and forth. I think the hospital uses more if we have that. But
yeah, I mean, I think that's a really good point, and I think it remains to be seen how free. I think early on, when the stabilization center is open, there may be some people coming to the ED that need to be at the stabilization center and vice versa, because the community will be getting used to how to use this model. For our services on the Deschutes County end, we have in our crisis stabilization sort of team, we have peers and we have case managers and we have some ability to transport people, and we have ways to cover that cost. How the hospital chooses to do that, I honestly believe that if an officer was told to take someone out of the ED and bring them to the stabilization center where they only have to stay for maybe 20 minutes versus hours, they probably would be amenable to that. But I think that will come out as we run that service and see how it works.
yeah.
When you're referring to transport from stabilization to somewhere else.
Well, both ways, actually.
Both ways.
Yeah. Just
Yeah,
that
and
connection.
there'll be needs everywhere, I'm sure.
Yeah.
Yeah, okay. All right. Well, those are all my questions.
So my thought, you were going to do the introduction. So this is state dollars, responsibility of Deschutes County Behavioral Health. We're working tri-county on this. My point is, St. Charles is providing these services. If they weren't, we'd be doing it in some fashion, correct? I mean.
Yeah, so the dollars are in a category that is specifically for intermediary and acute psychiatric services. And the CMH, the community mental health programs, have some responsibility to ensure, to the extent that we can, that those services are available. These particular dollars just pay for individuals who can't have their costs covered through commercial or Medicaid insurance. So they're really just for people who show up in these environments that don't have insurance at all, yep, or are underinsured. So it's a pretty specific pot of money, and the dollars are specifically for that.
Okay. Any further questions, or?
No.
Let's seek a motions.
I
Supporting
move
board signature?
for board signature of St. Charles PES/Sageview contract. Do we have a number, document number 2019-456?
And I'll second it.
Any further comments? Thanks for joining us today to explain this.
You're welcome.
Thanks.
Thank you.
Commissioner Adair?
Yes.
Commissioner DeBonne?
Yes.
The chair votes yes. Okay. So we'll turn to item number 3, which is consideration of board signature document 2019-789, the IGA with the Oregon Health Authority. I think we pulled this just to kind of walk through what this is again. It was not quite clear to us, I think.
So if you recall the Certified Community Behavioral Health Clinic Demonstration Grant, so we call it CCBHC-D, not E, is...
Say D, not E.
Yeah, it's the original demonstration.
Original, not the expansion.
Yeah, and actually you have in front of you a one-page handout that sort of walks through the differences between those, and then on the back shows you some delineation of
Look at this,
how
all in one spot. Did you come up with this?
No, Cheryl Smallman came up with it.
Nice.
This is
So just to revisit this subject, so the states that have been participating in the CCBHC original grant and the federal government have had a lot of interest in continuing it because it's been a good model, or at least a good initial pilot. And the federal government voted to extend it now through December. What that allowed was for us to extend in Oregon from September 1 through February 28th or 29th. I don't remember if it's a leap year or not, but through the end of February.
It is a leap year.
So through the 29th. The CCBHC demonstration grant, which if you recall is the grant that pays us through a prospective payment model rather than a set amount of grant funds. So it allows us to bill and have an additional payment on Medicaid recipients to cover the cost of the program. In order for the state to continue it, they needed to find revenue to create the state match to the federal dollars, which is roughly 4-to-1 or 3-to-1, depending on a number of variables that are complicated. But we looked at we came to you and asked permission to participate in that because we felt it was worthwhile because of the match ratio. And to participate in that, we were asked to accept a reduction in our service element dollars in some specific areas where we're allowed to do that. So this IGA amendment actually reduces those dollars as we had offered to do with OHA. So specifically, it reduces service element 1, which is for kind of general mental health system administration, by $26,300 some odd dollars out of a total of $375,000. It reduces our non-residential mental health service element $20 by $352,655. That's from an annual total of $758,438. These are all annualized, not biennial amounts. And then our service element 25 community crisis services by $381,000 out of $1.2 million and some dollars. So the projected, very roughly projected revenue is about net revenue is about $3.2 million this year. And then we are still continuing to advocate that when the legislature at the federal level convenes again, that they vote to continue this model. But that remains to be seen.
So I'm trying to match the 3.2 million up to the handout. There's a 3.4 for the expansion grant.
Yes, so 3.4 is what Cheryl modeled here. And again, it's a guess based on previous year's PPS payment revenue. And this year, our PPS payment revenue is a little bit less because we also have the expansion grant and we cannot double bill. So those claims are pulled out of what we submit to the state, if that makes sense.
The dynamic world of health budgeting.
Never boring.
Yeah. But yeah, so this was explained to us, the fact that this is the Oregon Health Authority, making sure that, yeah, they're not overfunding what they even thought, or cost control, I think, was the message.
One thing I was thinking about is I really appreciated how you didn't abbreviate or the acronyms when you actually say them, because people that are watching would have no idea, and I think it's really, really important that we really try and stress that. It kind of shuts out a whole group of people that shouldn't be shut out of government.
That's us. I
Well,
see a lot of meetings where, like the
No, but
forest meeting the other day.
It happens.
Right,
Yeah,
but I mean, I
that's
think
right.
it's really,
Yeah, no, I think it's
I think we could start a new trend where we actually say things in full so that, people's brains go, oh yeah, I know what that is.
Like certified community behavioral health clinics.
Yes, very good.
I like that.
Okay. So this is amendment number 4. Is that right? It says agreement.
Yes,
Okay, so what are 1, 2, and 3? How much money are those?
Oh, those were little amendments. One, gosh, I can't even remember what they all
I mean, I was
are.
trying to
Usually little dribs and drabs of fixing
Okay.
things. One moved money from one service element to the other, and it was a net even. One added money, $74,000 this year for our CATS program, which is, oh boy, I don't even know what the acronym means. It is our crisis services for youth, basically, is what it is. But it adds some dollars that we pass through to youth villages that will allow them to hire a family partner. And then the third amendment was moving things around, but at the end of the day, we lost about 4,000 in our Pathways to End Homelessness program.
4,000?
4,000.
Okay.
So say it one more time. This is part of the continuation grant?
This is part of continuing the original demonstration grant.
The 9/1/19 to 2/28/20
Yes.
portion, okay. And the expansion grant,
Is a finite period. It started October 1 last year, and it ends September 30th, 2020.
so
And that's the one
it's-
that's 3.4 on the backside.
So we're getting that now. Do we get paid like monthly on that or something when it's by the month?
That's the one that's 3.4 on the backside, and we get paid quarterly.
Quarterly. Okay, well, that's good to, so which one is the one that we're, the Commissioner Adair was concerned and talked to Director Allen or talked to somebody about? Was that the federal funding of this one?
It's the original, if you look at CCBHC demonstration
Yeah.
or continuation, I mean, they're really one and the same. One is the effort to continue, and the demonstration grant. And that's the one I believe that you had some direct conversations with a number of folks, including Steve Allen at the Oregon Health Authority.
And so we're in place till through February, but we're talking about getting federal support for after that? Is that
It's
what we're
supposed to be
wanting?
coming back in, yes. It may be, well, I think there's only 10 more days of session this year.
They
Vote on it.
had extended it through November 21st, and then they just did a little emergency coverage and extended it through, I believe, December 10th.
Something like that.
And then it remains to be seen how much work's going to get done in the next however many days.
I actually met with Pat Allen, but then Steve Allen was there last
Oh.
week at AOC, so I was talking to Steve Allen about it too, and what's going on and everything, so.
I hope he was in an advocacy.
He was.
Oh, good.
It seemed to, make sense.
All right, well, I'd like to get a motion supporting board signature of this.
I move, we have board signature of document number 2019-789, the intergovernmental agreement, is that correct? IGA with Oregon Health Authority.
That was a grocery store, IGA.
I know it is, isn't it?
Seconded.
Any further comments?
Good catch.
One question, do you expect there'll be more of these adjustments in this fiscal year?
We're expecting another adjustment any day now to fund the promoting integration of primary and behavioral health funds that the that OHA passed through to us. You got a request a week ago about a half-time admin support specialist that was funded through that. And the IGA.
We did it today, we approved it this morning.
Did you approve it?
It was on the
I thought that was a
consent
different
agenda
one.
today. We had
It
a work
was.
session about it, now it was approved today.
Oh, you had the budget adjustment for it, yeah. So that should be coming soon, and then we're expecting one other that is related to a project that I brought to you some time ago. It just takes OHA a long time to get contracts through. So we're expecting one other IGA related to placing peers in the emergency department. So
Okay,
lots of amendments.
Peers are very important.
okay. Commissioner Dare?
Yes.
Commissioner Bone?
Yes.
Chair votes yes. Thank you. for
Thank
joining
you,
us.
commissioners. Have a good holiday.
Oh, happy
you.
Thanksgiving. Don't eat too much turkey. Oh, Janice. Okay, well, that's
That's more important.
There you go.
Yeah, there you go.
All right, we'll take up the Deschutes Basin Habitat Conservation Plan and Support Letter.
Good afternoon, Commissioners. For the record, Peter Gutowski, Deschutes County Planning. Before you is a letter drafted by staff that builds on the panel discussion that occurred on November 13th. As you'll recall, there was Bridget Moran, who's the field supervisor for U.S. Fish and Wildlife Service, Todd Heisler, who's the director of, I think, their river conservation program for the Central Oregon Land Watch. Mike Tripp was representing Trout Unlimited. We did reach out to irrigation districts. We're hoping to get Ken Reich with Tumalo Irrigation District, but I think he just misapplied his calendar and had forgotten. The letter tries to do two things. First, it recognizes the financial hardships that the Habitat Conservation Plan creates for patrons and customers as it pertains to agricultural economics, specifically for Jefferson County. Those impacts become more pronounced under Alternative 3 and 4. I also felt it was important, just for of course, the board's consideration, is to acknowledge some of the limitations with Alternative 2, and that's the proposed action by the irrigation districts. And again, the irrigation districts were compelled to prepare a habitat conservation plan because their legal obligations for the 8 irrigation districts is to distribute and deliver water to their patrons. The city of Prineville is also an applicant, and their wastewater treatment plant is in the floodplain along the Crooked River. But for them to protect themselves through an incidental take permit, they needed to initiate, or they felt compelled to initiate a draft habitat conservation plan. And what Bridget Moran mentioned, again, the field supervisor for U.S. Fish and Wildlife Services, is reminding the audience that the Upper Deschutes is heavily degraded. It's been, experiencing enormous fluctuations in flow for 100 years. The river's been scoured. It's widened its banks. And the Oregon spotted frog, which is the only listed species under the Endangered Species Act, in the Upper Deschutes Basin, is not a species that migrates into what they call terrestrial or upland habitat. It stays where it's wet and where it's moist in the riparian area. And so what I introduced for your consideration was to acknowledge the limitations with Alternative 2. It doesn't contain a restoration fund, and as you recall, Bridget was acknowledging you can have all the water you want in stream, but if it doesn't connect to the habitat, it won't be successful. And so the restoration fund, which is something that's included in Alternative 3, could be an important element, of course, because it will connect the riparian, or the currently detached riparian area, to the river system with more stream flow over time. And also, more importantly, and Mike Tripp mentioned this, the Trout Unlimited representative, the ex officio representative, he acknowledged that the restoration fund could help move the dial to prevent parties from filing a lawsuit, from certain organizations, and any lawsuit is going to be extremely expensive for the irrigation districts, for the city of Prineville, for their patrons and customers. So again, for the board's consideration, I thought it was important to call out the socioeconomic impacts of what this habitat conservation plan does to the applicants, their patrons. Its effects are more significant in Jefferson County. Acknowledge that Alternative 3 and 4 pronounce those effects. And then, like I said, alternatively, I thought it was worth putting into the record that there are some limitations with Alternative 2, and that a restoration fund could literally be that bridge to blend an approach that relies on adaptive management. Again, as you'll recall, the Habitat Conservation Plan is not prescriptive. It will rely on a series of tools as determined by the applicants, unlike what I think Todd Heisler and maybe even Mike Tripp would like in a perfect world. It is a suite of options, and the applicants get to decide which ones are most timely, which ones are the most effective. So hopefully I wasn't too presumptuous, but I thought at the very least you would appreciate those two perspectives. And I guess I'll close by just reminding the board that the public comment period closes a week from tomorrow. And so to the extent that this letter is workable or you want additional edits, we'd need to finalize that on Monday.
So I'm a little bit confused with your second paragraph or second line item. It almost reads like we're supporting alternative 3. You say it's offers some advantages, albeit increasing expenses. First, it puts more water in the chutes. Then 2, coupled with the habitat, may minimize or negate litigation. So you're saying all those advantages, but do they have the option of, does Fish and Wildlife have the option of doing a hybrid?
I think, Mr. Chairman, I think the answer to your question is yes. Bridget Moran was acknowledging that I think they have an obligation to make sure that the Habitat Conservation Plan addresses the species needs from a take standpoint. As you'll recall, Alternative 2 does not contain a restoration fund. And so I was trying to acknowledge a sweet spot, so to speak, where a restoration fund could be beneficial in terms of supplementing the water that's going to be put in stream, whether it's through alternatives 2 or 3. As Bridget pointed out, that the irrigation districts may already be contemplating a restoration fund. So I don't, again, what's before the U.S. Fish and Wildlife Service and the NOAA Marine Fisheries Service is a draft habitat conservation plan. So this is the public comment period. It seemed to imply to me that these comments pertaining to the restoration fund may or could compel the irrigation districts to include it as an addendum. That's my language as part of maybe the final negotiation with U.S. Fish and Wildlife Service. But as Bridget noted, they have 3 options. They can approve, they can deny, or they can basically modify the proposal to meet their legal obligations. So, yes.
Well, just to finish up, so I thought when I started this, we were endorsing 2, but when you finish reading paragraph 3, it seems like we're endorsing 3, or when we finish reading paragraph 2.
This may not have been very successful. I was trying to walk the line and acknowledge the economic challenges, the socioeconomic challenges of Alternative 2.
But I get that.
And
So
at
you're
the
saying
same time,
this
looking on the other
This is
side.
what we've heard and thought about.
Exactly.
That's different than saying this is what we endorse.
Right, and I don't think
The question would be whether we want to endorse something,
And
specific action. Well, one thing is left out is, and I was going to add it to a sentence, but it's probably too much to run on, but in the first paragraph, you said, based on draft EIS, the board recognized the HCP will likely cause financial hardships, the applicants, the patrons over the next 30 years, unless there are large infrastructure grants or projects by the federal government. I mean, that to me is the real catch here, is that if we ever got a big infrastructure package, there may be money coming from somewhere else. So I don't know how we include that, but I don't think it's quite as dire as I just still think we're going to have an infrastructure package at some point. Maybe it'll be after the next election, but.
So if I may, the one thing that I recall Bridget acknowledging is that they have to look at the proposal based on what's known today. So
I agree with that. I mean, I
even
get
though that potential may occur, they can't factor that as a potential scenario. Not to,
Yeah, no, I
not to
get
diminish
that.
the importance of infrastructure funding and what it would do to accelerate putting water in the upper Deschutes.
Yeah. So, sorry, what were we gonna say?
Oh, well, I don't mind that, you know, the fact that infrastructure investments by some feds could change the dynamics here. So, I mean, you know, that could be just a kind of a hang-on
Us
statement.
recognizing
Yeah.
that or kind of looking for that.
Then also on item 2, I kind of go down that same path, so it should be real clear, because right in the fourth line or so, it says alternative 2 does not have limitations. But preferred alternative, maybe, you know, put one or the other in brackets, you know, referring to the preferred alternative to make it real clear. And then, yeah, I mean, I'm kind of half in and half out about saying we want to support a restoration fund as a negotiation for alternative 2. I mean, I see exactly what you were doing here, but it's a good point. I mean, this is kind of the topic of discussion. Would we want to take a position on it?
And just to underscore, in no way was I trying
Yeah,
to include language that this was an endorsement. It was,
Not a
I guess,
problem.
more of an acknowledgement that, because I did, I mean, if just scrutinizing the draft language, when we go back to the first paragraph, going back to the chair's acknowledgement, based on the draft ES, the board recognizes that's some stronger language. We recognize the HCP will likely create financial hardships. However, 3 and 4 are more pronounced. So to me, I was trying to acknowledge that there's really an understanding of the trying to limit, without saying so, the socioeconomic implications of those more conservation-oriented scenarios. And then with 2, just acknowledging that there has been this testimony, there is a recognition that there are limitations with the proposed action alternative 2, to use Commissioner DeBone's clarification. And, you know, maybe it's the fact that we often are dealing with the Land Use Board of Appeals. I was just throughout this public process as a cooperating agency, just to the extent that litigation can be avoided, is not something that's easily dismissed. My understanding is it could cost in the millions to litigate if they, turn to
Well,
our.
there's a
That's
point
our
where we
domain.
don't, yeah, that's what I guess I think too, is I wonder if at that point, I kind of like the idea of adding the word preferred before alternative 2.
It's the
Just kind of slant it that way, but then at the closing with your last sentence, almost, and then another sentence saying, and that may have advantages, we're not, I mean, at some point, I'm not sure how much this costs who, or at this point, I'm not sure, but I like the idea of a restoration fund, but I don't know how much this costs and how much of a hardship it is on who, and without reading, I mean, maybe you do, but that would have been an advantage if we'd had an irrigation company here as well as the others. They probably would have said, well, this is gonna cost us.
I think I'm meeting with Ken. I think I've set up a meeting with him because he did miss that meeting.
I have
Yeah.
heard commissioners of the fund receiving $100,000 a year.
From all the irrigation companies or proportionally?
That would be my understanding.
100,000 a year?
That doesn't
100,000 a
sound
year. How that's divided is unanswerable at this point.
That doesn't go, one, it doesn't cost that much, but it also doesn't go very far for this kind of restoration
Right.
work.
I mean, for the 2 statements here, I love, you know, the socioeconomic cost of crops and the land use associated with it, but this whole statement is kind of out of, we're not a party to the negotiations and legalities of it. You know, so I'm just saying, I could even drop the whole second concept, knowing that it's out there, we heard about it, we're talking about it now, but as Deschutes County land use citizens, it's more the domain of irrigation districts, you know, I mean, and we're all interrelated, but it's not our decision space.
Well, I'm good with 2. What's your thought?
I just have a question. The fact that they're saying our farm income is 2% of our economy, what year was this number attributed to? I mean, was this 17? Was this 16 that it was 2%? Is it still 2%?
Good question, Commissioner. I provided, in our early review as a cooperating agency, they initially were citing the older U.S. agricultural census, which I think is 2012, and the one that was updated and made available was the 2017 census.
Okay.
You think it's low or high?
No, I just thought with all the hemp that was grown in Deschutes County, of course, what happened with it, but it could have had a,
That'll be next year's results. Or,
right.
yeah.
We'll know next year, I guess, what happened, right? No,
Well, do you like the idea of the second paragraph, Commissioner
No.
Dare?
Paragraph number 2, well, I want to say, I prefer alternative 2. Yeah, I would like to have that just a little clearer.
And then, yeah, I mean, if it's some words around this mitigation fund could be,
Well, we're recognizing
I
like
mean,
what
that's fine,
Todd said.
it's just
and
a statement about that thing over there could be valuable, so.
The one thing I could, not to get into the weeds here, but I could, under paragraph 1, put this into 2 sentences. Based on the draft EIS, the board prefers alternative 2, and then I could say, or maybe it's a longer sentence, comma, while recognizing the HCP, and I would continue that sentence. So it would be
make it real
more explicit, and if that's helpful.
Yes.
Okay.
Well, it seemed like there was kind of a, both, it seemed like Mike and Todd were kind of, they were more gelling around 3 and 4. I kind of feel like it's really not totally about the frog, though. It's really about, getting water into the river generally. I mean, the frogs become an indicator species but it's really that the water's just too low for a lot of the
in the winter
people as well. I mean, with the big, anyway, so I don't know it's hard to know what the irrigation companies can endure or do, and I don't know. Well, do you want to, so, do you want to explain what a dry water year is? That seems like dry water. Is that low water or high water? What does that mean?
So, according to the Habitat Conservation Plan, its permit period is 30 years, and it recognizes that over that 30-year period, there are going to be years where the winter, where it's wet, and we have an abundant snowpack. Alternatively, there are going to be years where it's dry, and so the environmental impact.
Dry water year.
Yeah.
So it's low water year.
It's very clear.
Economic contributions decline in all counties. What does that mean, contribute?
So, the implications for the 3 counties, to the extent that we're in a drought, the implications, of course, will affect all 3 counties. We're the most diverse county, followed by Crook and then Jefferson. So I incorporated that language because I thought it really underscored.
What do you mean economic contribution declines? You
So,
mean from the agriculture?
yeah, so it's and I was lifting this language or trying to make this language more readable coming from the environmental impact statement, but it talks about that next sentence, the contribution from
Economic contribution from all
employment and income.
agriculture.
Yes.
From agriculture
yes.
declines in
Yes.
all counties.
Yeah, so it's the agricultural economics, exactly.
Medium water years under a high conservation scenario.
And then I tried to document to show the reader that the county recognizes what the implications, and if there, as you get from median years to dry water years, you can see that effect is more pronounced. I think across all irrigated lands in the 3 counties over the permit term, in a medium water year, changes in annual forage grain production value may range from a 0 to a negative 2.5 million, and then it goes, as you get to the dry years, it goes all the way up to, a decrease from 1 million to just under 10 million. And of course, 3 and 4 pronounce those implications, again, more so on Jefferson County than Deschutes County.
Well, I
because,
get that.
yeah, we're
What
s-
is so in a median water year, under a high conservation scenario, what's a high conservation
The
scenario?
high conservation scenario, I think, is if you're putting in more water in stream. That's alternatives 3 and 4.
There would be no impacts. Well, doesn't it, if you put more water in stream, doesn't it actually, don't you have less saved up for the summer, or isn't that?
Correct. There's going to be less to distribute to your patrons.
So there'd be, so it's high conservation because,
They're putting more water in stream during the winter months when there's no way to store it, and it runs all the way through our river system to Lake Billy Chinook. And so you're impounding less water and therefore making less water available during the irrigation season for patrons.
so wouldn't that must be a low conservation scenario then? When you put more water in, isn't that low conservation?
No, I know it seems counterintuitive. So the conservation alternatives are 3 and 4, where they want more water in stream during the winter. So
More water earlier.
they want
They all
water
end up-
during this time of year, from essentially, let's just go to next month, to December to March. The thought is you would, again, the frog uses its habitat year-round, so they want to try to lessen that hydrograph that typically spiked in the summer and then plummeted during the impoundment years during the off-season. So
You see where I'm struggling
Yeah.
with the high conservation scenario? That isn't intuitive. Like you said, it's not intuitive to me that when you put more in the winter, it's higher conservation. It seems like it's.
yeah, because the frog's going to.
It is higher.
They're going to be wet and in their habitat.
So it's conserving of the frogs.
Yes, think of
Not
high
conserving
conservation
the water.
is the water is being used for a wildlife-related, for ecological
It
value.
would have been, what would have happened without dams and all controls and everything, more of a normal.
We're trying to it's all about making the flows more ecologically relevant. And again, I was using that language from the draft EIS to support the prior sentences, which is, the county recognizes that the draft habitat conservation plan does create significant economic impact, and it's only more pronounced when you look at 3 and 4, and those subsequent sentences are trying to bolster that so that, again, we understand the implications as documented in the draft environmental impact statement.
Okay. Well, maybe we just add the words, economic contribution from agriculture declines in all counties. That way that's clear, from agriculture in dry water years.
Economic contribution from agriculture, sure.
That way
Yeah, that's a
makes
great
sense to me.
Thank you.
And when you're putting more water in the river, in the winter, you're saying there'd be no impacts on production value. Seemed like they'd go down then. Production value would go down because you're not saving the water up. Isn't it reversed?
What sentence are you referring to?
In median water years, under the
Almost
high
to the bottom.
conservation
Yeah.
scenario, there would be no impacts on production value.
And that's, Commissioner, I'm just relying on the environmental impact statement. I would be making assumptions at this point. Why that? Nonetheless,
'Cause I thought that was the point, is you're trying to get the water down the river in the winter, which means you save less for summer. And so it would be less production value, but I don't know, maybe not.
I think, yeah, again, there may be, yeah, I would be trying to piece it together. I mean, the production overall may not be significant, whereas you note it's not a reduction in crop value. Nonetheless, the changes in production across the 3 counties, it does go down. So it's a way that they're trying to capture the economic impacts from, a new water regime. And I apologize that, yeah, this is reaching the, you know, the edge of my expertise, you know, as a.
Well, it's hard to summarize, you know, like you were trying to do, so that
Yeah.
makes sense. Okay. Anything else you want to put in or ask Peter about, or?
No, I thought you just did say that in the second paragraph, you were going to clearly identify that alternate two is our preferred.
Yep. I'll note it as a proposed action and the preferred.
In case they forgot from
Yeah,
the first
sure.
paragraph.
Well, it's kind of implied in the first paragraph, but it's not.
Well, and the reason I get that, because it talks about alternative 3 and 4 in there, and then, yeah, just kind of make sure you're naming it.
Or alternatives 3 and
Yeah.
4 are more pronounced.
So if you would like, commissioners, I know, well, and maybe there's not enough time, but I know the chair is gone on Monday.
Yeah.
And so if you like, I could make some edits in just a few minutes and bring it back, maybe I know you have an executive session when you, or excuse me,
Right.
after the Thornburg
Let's try.
follow-up. Would that be?
Try to do it today, and then we're also, are you around tomorrow?
I'm tomorrow.
Yeah, I am
Okay.
too. So you can also catch it
Okay,
through
great.
Laura, probably giving it to her, and we
Okay.
could get it signed too.
Great.
During the
So then
day.
the move approval of the letter as discussed.
I'll second it, the motion.
Okay. All right, Commissioner DeBonne,
Yes.
Commissioner Dare,
Yes.
and Chair votes yes.
Great. Thank you. See you soon.
Thank you, Peter.
Thank you. Okay, so,
Yeah, apparently Jacob and Adam are on their way down.
okay. So we're gonna go back to, well, I got one short item. So here's our inspection report.
It says actually it'll be 10 minutes. They're making copies.
That's fine. We'll do a couple other items. So this was what I'd written up, and then one of us wasn't here, so I was gonna ask. Pass this to Tom if you want. Pass this to Dave. I'm sure he's interested in the jail inspection report. So I just was wondering if you can't read it, I made a copy for you, but this is just my rating schedule. We're supposed to turn this in, so. Had it for a month, I guess. So. The first one says improvements with scanner, new furniture, painting. Those were the facility. Couple things I didn't think we really knew about, so invented the BSOT.
Mm-hmm.
Beyond.
Okay, so yes, I would give them an excellent for their menu, because they were doing something yummy when we were there.
Okay.
And you could tell that they are painting soothing colors, so.
That was under facility.
The bottom one, interior condition, maybe too. And the medical, I know they're really trying on that one, so I would,
Where's medical?
in the middle,
Oh,
you gave them excellent, and,
I didn't have any comments. You want any comments? Is that what you're saying?
you know, we have it seems like a very well-organized health department there for them. You
It
know,
seems like there's enough people to.
right, there's a director, and yes. Didn't she come from like an orthopedic group or something? The woman that's running it?
Can't remember. So well organized and then, well staffed.
Mm-hmm. Yes.
Okay. Any comments on any kitchen, general housing?
The kitchen was clean.
Okay. Mr. Bone, you better chime in on something.
So inmate
No.
grievances, so beyond scope, you mentioned, we just didn't hear about it.
Yeah.
We have heard about it in the past, so I'm just, it's a point of reference that I do know that, there's slips of paper available. If somebody wants to write something, hand it to a guard. explain their situation. There's a grievance process associated with that, so it can escalate up. I have been introduced to that in the past. But yeah, I mean, we didn't talk about it this last tour, I agree. And leaving this document, with an rated item, could be a follow-up, something in the future. These are just a document that was created here locally for getting some words on a page. Because we also received a grand jury jail review recently, and I went through that. And it's good because that's a group of people that have, just doing a month of service, and they take some time and go see this facility.
Yeah, that's interesting.
When I think of the kitchen and the laundry facilities, I do support the fact that at some point we're going to want to and need to invest in the next generation and a little bit more elbow room. There's a lot of
Where is that?
utilization. Is that laundry and kitchen?
Oh, yeah.
But it costs money, so if it's just a commitment in the future for adding capacity to those.
So we make a note of that, need more space or something in the kitchen?
Well, I was going to say, so the lower we rate it, the more it's going to show up on our annual budget
Well, it's-
request. So I'm just saying,
it's
as a
rated as
commissioner,
excellent.
Yeah, but the facilities are throughput is fine right now. The inmates working there were happy to be there, obviously, and they were showing us everything that was going on. But it is a little bit cramped, and just the flow of how much production has to happen there.
I noted the work center was satisfactory just because but maybe they're going to allow us to use it for the warming shelter, so maybe I should, but it just seems, inefficient.
So is that ready then to go? Because it's supposed to be, what, 4 below or something this weekend? I mean,
No, Commissioner, there's work that has to be done to create the separation where the work center population is, regular population, plus there's some external fencing and so forth that needs to be done. It's obviously a high priority. We're also in the process of negotiating a use agreement with the operator there. They expect within probably 2 to 3 weeks should be ready, but it's unfortunately not ready for the cold weather this week.
So what is the public going to be thinking then if someone does need to go to a shelter?
Well, didn't we announce it was next week? I think that's what the press release said, is next week, not this week.
I know, but it's going to be 4 degrees below zero. So I'm just wondering.
Have to go to churches.
All right. I mean, will the churches allow it, though?
I don't know. But
I just know it's going to be really, really cold for a couple days. Or according to the weather forecast. So, I know Lapine's covered, Sisters is covered, Redmond's covered, but what about Bend?
Well, we don't have any, do we know of any options, or?
I don't think
I mean, nobody else has really stepped up to offer anything. that I've
I
heard
know,
about.
but I just.
Presbyterian Church was going to do some things, but.
Well, and they may still be working on it, but yeah, they need to get some approvals also. Just health and safety.
Yeah.
Well, and having this facility coming online a few weeks from now, maybe empower somebody to be able to open their doors this weekend, this week, knowing that.
Something else is going to take over. But what about, does Gwen have at Bethlehem Inn, does she have vouchers, a couple of vouchers she can hand out then? Because I know she said that doesn't always work, because then you have damage, and then who pays for the damage?
Well, the person to ask would really be Colleen.
Okay, Colleen and James.
Yeah.
Okay, all
That
right.
would be the person to ask what they've got set up for this week.
I'll call him. I'll call James.
Isn't that what you're saying, Tom?
Yeah, I mean, we really can't let them in until it's ready, until the agreement's in place, and they're working as fast as they can to make that happen. Commissioner Henderson's correct. What I had heard is that, even with the work center, it doesn't meet their goal of 100 beds to have in place for emergency shelter, so that they were continuing to work with the churches to kind of fill that gap. I'd heard from the city that at one of their Counselors was still investigating potential private locations around the city. I'm not sure where that went, but yeah, short of, and I know Bethlehem Inn, does have some capacity. They have certain conditions, obviously, that would preclude perhaps some homeless from residing there, but that has always been there. That will remain. But that's just kind of where we are now from the county perspective.
When it gets that low, it's really kind of an emergent. It's more like an emergency, like a flood or a hurricane or something. I mean, in terms of the cold and
You hope it's
damage.
not worse. You hope it's not like a couple years ago when it was 29 below. I mean, was that, the forecasting is never quite a science.
It isn't. You're right. All right. Well, any other comments on this?
That
I'll make
document,
those-
we've, had it filled out kind of on the table in the past at the facility.
Yeah.
I'm just acknowledging that, we can.
Do we need
sign
to
it and
sign yours?
provide
Yeah,
it
why don't you
back.
just sign it? I'll get it back to him.
That's fine.
That's why I brought it up today,
Yeah.
so I can get it back to him. I know it's kind of,
But yeah, as I
you
said, I
very
don't think
much.
it's really been part of our meeting minutes in the past. We have done this annually, though.
all right.
Or
Do we have
I
any
did
other
it by
items?
myself last year, though.
Did you?
Oh, I do.
Yeah.
I wanted, Gus, from the Veterans Housing Integrator from the state, sent me a wonderful email about a veteran. Sean had moved into Redmond, and they purchased less than 2 acres, and they want to do a tiny home possibility there. So they're going to come.
Really?
Yeah. So Gus sent me all this. He's a veteran. He is a colonel in the Oregon Army National Guard right now, and he's still working. And they're going to come over in January, and we're going to get together on that. So I thought that was great. And then I would like to bring up for our team that it would be wonderful if we could have our veterans office open 5 days a week. I haven't given up on that idea.
But what is the status of that? I agree with that. I think they should be open 5 days also.
They're going to start. They're going to do a pilot with less staffing that they would normally have on Monday through Thursday and track the response, see how well used it is. And if it turns out that it is, as popular as the rest of the days, they'll go full time on Friday. So we are moving in that direction.
Are you saying they didn't think they'd be used very well on Friday, or they're going to test whether they were used on Friday, or?
As you may recall, the vast majority of their business is by appointment. So they set up appointments in advance for clients, for veterans to go over their benefits and do their thing. So they don't typically have a large amount of walk-in business, but there is some. So certainly they want to be as responsive and helpful as they can to their population. So they'll try this out, and if it proves to be worthwhile primarily for the veterans, then they'll go full time on Friday.
Great.
To me too, there's just, that it seems like that's something like, I know the courthouse has limited hours for things, and it sends a different message when you're not open the same time as other businesses. It makes it sound like you're you're really short of resources, which we really aren't, or you don't care. So even if not very many people use it on Friday, the fact that you're open looks, is good for the community, I think, the image.
Well, if the federal government is open here on Fridays, I think our county government should be open on Fridays. So I'm hoping, and they said they could see a need that we could be open, so.
Good. Well, that'll be good
So
to
I think
try.
that's
When are they
great.
going to start that?
I'm not sure, Commissioner, the exact date. Eric just mentioned that to me last week, so he was going to do a full update for you. I'll ask that happen as soon as it can.
Good. All right, good.
Great.
Looks like we're ready to go so we'll go on and discuss the Thornburg deliberations some more.
Yeah, and we have a draft decision fresh off the presses. I'll pass that. Okay.
Okay.
Thank you.
Oh, in the electrical circuit, yeah, well, I don't know,
Haven't done that before.
haven't? Let's get paper towels, yeah. But that's the second water I've spilled. You know, I broke the glass today.
It's okay. It's how I feel after all my peanut butter for lunch, right?
Mhm.
Yep. So now we're gonna get it out of? Yeah, out of that. Let's not have any sparks. Oh, thank you. I carry those in my pickup.
It's one way to get the counter cleaned.
Somebody's got it. I noticed it, I didn't want to say anything, so I'm like, I'm complaining.
Okay.
Waiting for the lights to go off with those switches.
Just take one.
It's always on a day when I've had peanut butter for lunch.
Clean water.
Yeah. I know, it went in, it went into the outlet. Well, what do you think? I'm looking for a good electrician, so someone that will follow me home and put my light up.
Yep.
Well, so much for that. You're full service, Jacob. Suppose it's too much to get another glass of water.
I haven't had mine. Oh, wait, I've been drinking out of it.
Here, this has been sitting here all day for Eric, if you don't want mine at all.
Okay.
Yeah.
Have you got your?
We'll just fill it half for you.
I have.
Oh, I didn't. I could have done that.
There you go.
I'm happy to do
Oh, we've got one. This was Eric.
Okay, thanks.
One.
Sitting there since this morning.
Let's see who hasn't got.
I give one to Tom.
You.
I give one to Tom.
Dave.
Got one.
I think we got.
Oh.
Okay.
Oh. Okay. Well, with that, we'll proceed to. It's Thanksgiving week.
Okay. Yeah. For the record, Jacob Rippers, Senior Planner with CDD. So during our time away, we incorporated some of the findings from deliberations this morning into the draft decision that's in front of you. I don't know if the board wants to take a minute to read through it, and we can continue deliberations or edits afterwards.
May we?
Yeah, we probably are going to need probably more than a minute.
Yeah.
Would be my guess.
2
It
minutes.
looks like a
Yeah,
couple minutes.
absolutely.
What's that? Oh,
So there was an extra one here. So
There was Eric.
there you
thank
go.
you.
It's good
Oh, my
service.
gosh. Ready?
Yep.
Okay.
Yes.
All right. Good job getting this done in a short time. So I have a couple questions. One is, I didn't think we could remove condition 17. Am I wrong about that? I mean, it says here that we unanimously voted to remove it. I thought we were voting whether or not, if it wasn't there, whether we'd meet the source requirements. But I didn't think we were actually voting to remove it. But, so.
Yeah, the LUBA instructions ask, can the tentative plan be approved without that condition 17? So I think in order for the 2018 hearings officer's decision to stand, we would need to delete that condition if it were to be approved.
Well, I don't know, and I remember reading arguments somewhere in the body of this that you can't remove 17 or something, that maybe the applicant had asked to remove it and it couldn't be removed or something. I don't know. I'm just bringing it up because I thought they were just asking us to think about whether it could be met without it, not take it away. So
The appeal from the applicant is the request to remove that item. That's the current scenario we're working under, isn't that correct? That's what the appeal
well, we're on the
is.
remand.
Yeah, but I mean, the remand appeal to us from the applicant is to remove that item.
Right, it's on page, in item number 87, it said, we must consider whether, without it, the tentative plan satisfies.
Yeah, and
I
if
get
I understand,
that. I
that's
agree
what he
with that.
said, yep,
So-
yep.
I agree with that. I just thought there was, I don't know the record as well as you do, but I thought that there was an argument that you couldn't remove it for some reason. But they wanted to know if it wasn't there, was the source good enough, or the water source good enough to meet this Fish and Wildlife mitigation? So you can track this somewhere where it says it's okay to or that we have to remove it, or?
I do remember, just off the top of my head, there were arguments regarding the LUBA appeal proceedings, and that the applicant didn't essentially ask LUBA to strike that condition from the
Right,
decision.
that's what I'm saying, yeah, at LUBA, so you can't bring it up now or something, or you can't try to strike it now. Because that wasn't what was remanded to us.
My understanding of the remand was that it was inviting the county to reconsider the approval either absent the condition or with a modified condition. And so I think that certainly empowering the county to strike the condition in its entirety. I think that
Well, it wasn't in that, that isn't what that one paragraph that we focused so much energy on said. And maybe somewhere else in the remand it says that, but.
Well, I think that's logical, considering the original approval without condition 17, and if the board thinks that condition 17 is not necessary for the rest of the decision stand, then it's effectively removing the condition and reapproving that same decision again. All of the other arguments about that decision were, LUBA upheld that decision in its entirety except for the issue regarding condition 17. And so the result is that the rest of that decision will be a valid decision. We could
Yeah,
tweak the language if.
Well, I just want to make sure of that, because I remember it seemed like the applicant had asked to remove it, and then there was argument made, well, you didn't raise that at LUBA, so you can't remove it during this process, either at the hearings office or with us.
My recollection was the arguments in front of LUBA were that the applicant did not cross appeal. The applicant didn't appeal the county's decision to LUBA.
Right.
And so in order for the applicant to argue that LUBA should just strike that condition, they would have needed to appeal the decision themselves. LUBA treated that argument as a cross assignment of error, so to speak, which they're not allowed to bring without filing the notice of intent to appeal themselves. But perhaps I'm misremembering the exact issue.
I just bring it up. I'm not saying I'm necessarily right. I just bring it up because I remember those arguments, and I was concerned because the 17 really talks about other stuff too. It talks about the overnight lodging units and it talks about building permits. I mean, it's really a whole, you know, I don't know if it is necessary for this tentative plan, but
And correct me if I'm wrong, but Jacob, you did the analysis that there are other conditions of approval that will address the overnight lodging unit piece.
Yeah, and the timing of that is addressed in the FMP approval, and there's conditions about when the first 50 OLUs need to be built, that there's deed restrictions on the single-family lots until those OLUs are essentially up and running.
so when a hearings officer makes a conditions like this, and we've done a lot of conditions on our marijuana decisions, where we've said, well, they need to do this, and they need to do that. Those are kind of the decision maker just saying, we want to make sure these are done. Was that true here, that the hearings officer was putting conditions on because they weren't sure about this or that, or, I mean, that's kind of how it feels a little bit with this one.
Yeah, in that decision, he discusses a little bit about why he imposed that condition, and essentially opposition had raised enough uncertainty for him around the water issue, if the resort could secure the water rights, that he wrote the condition as it was written. A little bit of flexibility, or just show that you got the rights that were approved in the FMP and FWMP.
Okay, so we think we can take it out, and we're not breaking we're not exceeding our what we're being asked to do, I guess. Okay.
That's not from my understanding of the scope of the remand, no. I think you were invited to take it out by LUBA.
Okay. So I've got a couple other questions, but Commissioner Dare, any specific questions, or? Commissioner DeBonne?
No, I did have a question on page 6 of 10. Do we know when Big Falls Ranch will discontinue pumping? It said when Big Falls water rights are purchased, then they're going to discontinue. So that's an event in the future. But it has been specified.
Yeah, as I understand it, it's going to be a series of multiple events, because not all the water rights will be purchased at once. So as soon as that group of rights is purchased, then they discontinue pumping from their well. The resort is required to transfer those water rights permanently in stream into the Deep Canyon Creek.
So my understanding, I had that underlined also, is that they already aren't pumping that water. So aren't they really discontinuing their right to do it, or because I thought basically they transferred it to I guess to groundwater, because I bet it's because they're no longer diverting, so they're going to lose their water right after they don't use it in a certain amount of time, so they've converted it to something they could use, or it's mixed with others, but so I wondered if that wording was right, will discontinue, or will have to have discontinued, or will, so I don't know. I had the same questions. You know what I'm saying, that in the record, it seems like they've kind of said they have the right to use it as a groundwater, but they aren't. I thought that's what it said, but.
So what Big Falls Ranch has done is transferred the water rights associated with Deep Canyon Creek. This is the point of diversion, point of appropriation conversation that's in the record. The applicants argued that it's still a surface water right. It's just the point of where they're getting the water is different. So it's the same water right that the resort needs to purchase. It's just the fact that the water isn't being physically diverted from the creek right now. The creek is not the source of their irrigation water.
Right. Okay, so you think the will discontinue, even if they're not doing it now, is okay?
We can certainly put some more discussion in around the water transfers and.
I mean, I may not be right that they said that. That's what I recall them saying, is that they weren't currently, they transferred it, but I think it's because, you know, they transferred from a diversion, which is a stream diversion, to a groundwater use, but
So, and I think of this as, you know, the water rights shall be allocated to the parties legally, and, you know, I mean, if somebody gives up a right, that means they're gonna stop pumping. So I'm just saying that last sentence on the page 6, when Big Falls Ranch water rights are purchased, Big Falls Ranch will just continue pumping the groundwater associated with that, the rights purchased. I mean, it has to happen. It's a legal thing, you know.
It's similar to buying and transferring any other kind of water right.
Yeah.
You know, two parties don't get to use the same right at the same time.
well, actually, what they said is that when they actually do the sale to the resort, they actually are gonna go back and change them back to the creek to, that's what I thought they said, but I don't know. Okay.
Yeah, so the applicant's argument is that despite the change in location of this diversion and appropriation, the water rights remain surface water rights associated with the creek. And when those rights are purchased, essentially the requirement is for the resort to permanently put those rights in stream in the creek so that the cold water flows.
Okay. On page 4, the hearings officer was the hearings body for the proposed TP, SP, and MA applications. Can you put the words in there for, we just had this discussion on another matter that when we were, just identify what those are.
Absolutely.
I mean, you can use them later, but. Another question I had was about the use of the word incorrect class of service. That it was mailed with the incorrect class of service. It seems like you gave some thought to that. Do you want to mention that statute that we're talking about there? Is it 19 something? Because there is a part B to that statute that says you can do it by certified or.
We certainly could.
May reference the statute?
Yeah, we can reference the statute that requires, or I can't remember if it's a rule or statute, but we can certainly cite.
Oh, it might be a rule, yeah, I don't know.
Cite to the requirement that's, and be more specific with, that they use first class instead of certified mail, if you want the specificity.
Well, I don't know, maybe you thought incorrect was the right, I'm just bringing it up.
I think from the board's perspective, agreeing with the applicant's argument, at least as of this point, you know, it's untimely. I think that's the important takeaway, is that it was an untimely filed appeal. And it was untimely filed because it was the incorrect mailing. Getting sucked into too much of the details of that, why that was incorrect or how it was incorrect, is really, that's the issue that has been appealed to the Supreme Court.
Right.
And until the Supreme Court tells the county, tells the board otherwise, my understanding is the board is following the applicant's argument that it's untimely filed. And so I wasn't putting too much detail into why it was untimely filed, because that's, I would argue, a separate matter. Right, it's a pretty layered argument. The jurisdictional piece takes several layers before you could say, oh, we don't have jurisdiction. And I think what I'm hearing from the board is a more simpler understanding that, hey, as of right now, nobody says we don't have jurisdiction. All we know, the only issue, the only decision, the only order, the only anything coming from the appellate court system are 2 decisions from the Court of Appeals dismissing the appeal. And the applicant initiated the remand within the 180 days. We now have 120 days to process that remand and issue a decision, and by golly, we're following our statute. That was kind of the message I was conveying through that jurisdictional piece.
Well, I guess, yeah, what I was wrong was the incorrect. It's okay to do first-class mailing, but you have to do longer timelines.
Oh,
don't
I
you?
see your point, yeah.
You see what I'm saying? It's okay to do it, but it's 3 business days as opposed to 3 days or something, or it's real technical. But anyway, I don't know.
Yeah, we could just, yeah, we could change it for causing the mailing to get to the court late and thereby causing the court to dismiss the appeal. I mean, we can strike the word incorrect and just say mailed with a class of service that caused the petition to be received by the Court of Appeals after the filing deadline.
Something like that.
Yeah, here, I can,
That makes a little more sense.
okay.
I think that incorrect is used it back somewhere else too, on page
Maybe in the back.
8,
Oh, okay.
right under the started jurisdiction.
We'll do a quick word search and correct it.
Well, it's pretty, short and sweet here. It doesn't say how we get to the conclusion on the water source, but it says we get there, right? Because I was comparing it to the applicant's suggested findings, and they go on to a lot of detail, but they're kind of responding, so I don't know if we need any more detail, and whatever you think we need. Does anybody else have any comments?
Nope, I highlighted items, but I mean, they weren't specifically questions. I'm just looking back through here, so, it does end up being a little bit more, compact and concise, which is nice. Laying this whole thing out and now bringing it back.
Commissioner Dare, any more comments?
No, it was such a complicated issue, and what is it, 10 pages?
Tom, did you have any questions or thoughts? Or?
No, I think they did a pretty thorough job.
So just acknowledging this morning was discussion, so it does mention, votes. So it's, bring it to an official vote of either now or the document in the near future, or however we're going to do that.
And I quickly just came up with some language on the incorrect class of service issues that I'm happy to read into the record if the board wants to go forward with approving the decision with the changes noted by staff, just to allow us then to finalize the decision and get signatures on it tomorrow, as opposed to you guys having to convene a meeting to approve it.
Yeah,
I'd support hearing the words.
The words
Get
sounds
there.
good.
All right, so on page 3 of 10, second paragraph, second sentence in that paragraph, I propose that we strike mailed with the incorrect class of service causing the court to dismiss the appeal as untimely, and instead have the sentence read, the Court of Appeals did not accept Ms. Gould's appeal because it was received after the filing deadline. And we don't need to go into too much detail there. The detail will be covered in the jurisdictional piece. I would note, sorry to go back, but on page 2, Jacob has a note at the first sentence of the summary of the decision. Luba remanded a 2018 county hearings officer's approval. Right, there's so many different county hearings officers' approval in this matter. It's helpful to just specify which one we're talking about. Page 4 of 10.
Where'd you do that on 2?
Right down below.
Just the first sentence under summary of decision, just adding 2018 in front of county hearings officer.
Oh, okay.
That's a good idea.
On page 4 of 10, we'll spell out the TP, SP, and MA in that first sentence of the finding.
Thank you.
And then on page 8, under jurisdiction, the second sentence, I'll just read the new version of it. The Court of Appeals did not accept Ms. Gould's appeal because her attorney mailed the appeal with a class of service, causing the court to receive the petition after the filing deadline. Thereby, the court dismissed the appeal on July 18, 2019. And then the paragraph will continue on from there. And then the footnote, it's supposed to say August 9th, 2019, not 2012. That was a typo.
Oh, good.
Yeah.
Good catch.
I have one more question, I guess. Well, on page 7, you caught where you need to move the paragraph up, right? After the word water, comma.
Oh.
We will correct that.
You got that?
Yeah.
So on page 6, before that, in these proceedings, the applicant removed any uncertainty about whether it can purchase, et cetera. When you say any uncertainty, it makes me, I mean, there's probably some uncertainty somewhere, but you don't really have to have remove any uncertainty. I mean,
You just have to determine that the condition is feasible. It doesn't have to be bulletproof, so.
yeah, I just thought that was a little strong, but I don't.
Just remove the word any?
Yeah.
So there's,
Is that
remove
good enough?
uncertainty?
Yeah, yeah. I just don't want to overstate her. Because I suppose there's always something. Okay.
It's of course the board's discretion. I mean, we can make these changes and bring it back to you tomorrow to approve the actual decision, or you can, of course, have a motion dictating your decision and approving this draft decision with the changes indicated by staff. It's the board's discretion. Being
I think the latter is probably the simplest for us, rather than come back just for a vote. I mean, I think they weren't, you've explained what it was, the 2 or 3 that were, only one of them, well, a couple of them are substantive, I guess, but they aren't. Okay. So wouldn't you just assume to vote on now?
Yes.
Yeah, okay.
Support that.
So, any other comments, Dave?
Well, with those changes, they captured it well. Good job.
Okay.
So this is a document number 804, is that what we're looking at?
804, yes.
Where do you see that?
Just in the very bottom of the front page. Just the Board of
Oh, yeah.
Commissioners decision.
Okay.
So, yeah, with the discussion and the proposed amendments to this draft, move board approval of a decision on document number 2019-804, removing, well, I don't even want to say anymore. So, yeah, I could go on and on and on about the history of that. So this document.
This document with the, what'd you say, with the changes?
As discussed in this draft, yeah.
Okay.
I'll second the motion.
Any further discussion? Do we need any further discussion? Okay. Commissioner DeBonne?
I guess, yeah, for discussion, so, I mean, the bold highlighted item is condition of approval 17 is hereby removed. That's kind of the conclusion of this whole thing. With that discussion, I vote yes.
Okay. Commissioner Adair?
Yes.
And the chair votes yes. Thanks for getting this done, and
Thank you.
We'll certainly get this finalized, and just for scheduling purposes, commissioners will be in tomorrow for signatures, because we have to get it in the mail. Okay.
I'll be around.
Yes.
We'll coordinate with you.
Why don't you coordinate with Laura, and she'll make sure she gets it to us, or?
We had yeah.
They're probably still here for another hour plus, so.
Actually, yeah,
Maybe we could
knock
do it
this
today.
out.
Yeah.
Yeah.
Well, we don't want to put too much pressure on you, but yeah, if we're still here, we can do it today, I guess, and.
Yeah.
Well, thank you for helping get us through all this, and.
That way, if there's a foot of snow tonight, you don't have to worry about
What about 2 feet?
finding
Is there
signatures.
supposed to be?
Hey, do they ever say when we're going to have significant snow? No.
All right.
Jacob?
So.
When is your last?
Oh, you've got your final draft too?
Next Thursday. Okay. Well,
Well, good job. Thank you for getting us through this. And okay, yeah, Peter has a final copy, I guess, of the or on the habitat conservation plan.
thank you.
So is there two of them? Oh.
Changes just so you can see edits that have been made.
So the proposed action terminology in the second item, that's what it is. It's a habitat conservation plan. This is the proposed action. Instead of preferred alternative, I guess was the terminology before.
Correct, Commissioner. I was duly corrected by Bridget Moran as well.
Good.
The NEPA language is typically preferred alternative, but they call it proposed action.
Okay.
Were you corrected by her on that today?
No, I was, I
that
think
was
just in preparing for the panel discussion, I wanted to make sure I was introducing it correctly, and she said it was not the preferred alternative, it was the.
But so that's what I was.
Yeah, exactly. It comes out of the National Environmental Policy Act is what I think of the preferred alternative.
I'd almost be willing to add a sentence to the end of the second paragraph to the extent of, perhaps, given, this is not very good, more understanding of the economic impact, we might be supportive of that restoration fund. I mean, or economic consequences or economic costs or something. Around that line, but I don't know if you guys are interested. In other words, I almost want to leave the door open about the restoration fund, depending on, but I don't know enough about the economic costs to do it. I mean, so.
Paragraph 2 ends up being a discussion about, the other proposed actions or alternatives or whatever.
Might strengthen it
by saying. What would the?
Well, if we were given more clarity or of the economic costs or more, clearly what they are. I mean, you'd sort of maybe 100,000 a year, but that, I don't know.
Well,
I kind of like the idea of putting that in as the fact that we're aware of that issue. I mean, I am.
Well,
if we're going to do this.
I mean, setting an amount over time. Yeah, I mean, no way, we're not qualified to say that, this first 100,000 is going to save X amount or whatever, or we need to wait 10 years and add them all up to do some big thing. I mean, that's.
Well, and what I guess I'm saying is we go into the issue that does offer some advantages, and we say what those are, but we don't say what we think about them. And I'm not ready to endorse them, but I do think, given more clarity or whatever, I might be supportive of that. I really don't know enough about it to know. That's all I'm saying. What do you think, Commissioner Dare? Do you want to, in other words, rather than just saying, here's the great things about it, but we're not gonna say what we think.
Well, right, because we're not really saying what we were told that day. You know, the fact that we have flood irrigation in one of our water districts that uses a lot of water, that if that was reevaluated, it could perhaps be better for agriculture in the whole central region.
So that
Which I agree with that.
Yeah.
$100,000 may be much better to grant to those private laterals.
Yeah. Anyway.
Did we vote on this, or?
You have not voted on it.
Yeah, I could support dropping that whole second statement. Think about it, it could go either way.
No, I like having a little, otherwise it seems pretty thin to me.
No.
So I'm good to keep it.
I'm happy with it. I just think that there's another issue out there too.
Yeah.
Well, we haven't said that. We haven't said anything about that.
No, I know.
You know, see, I'm supportive of things like the changing the farm practices. We've already done that on our farm. You know, we don't do very little flood irrigation, more pivots, and just because it's wastes so much water. And then if I was going to close ditches, I would close those laterals or pipe them.
Well, I wouldn't call it wasting water. I'd say it's a maybe not efficient use for agricultural purposes, because some people rely on it for groundwater recharge. You know, we've distributed water from a natural system throughout Central Oregon. You know, so calling it a waste directly is.
Well, it's a waste for what you're doing with it.
Yeah,
Well, I
exactly.
guess
Yeah,
you
for
are
agricultural
recharging. You don't need to grow the plants.
Yeah.
I mean, we used to flood where we'd run through a cornfield all day long, you know, and
I know. I've seen
1/10 of the water
it.
actually goes to
Tailwater
the.
just flies off whatever, down a canyon or something.
Yeah,
No, my family used to flood irrigate, and I don't think they do that at all.
yeah.
anymore.
No,
They have,
that's
but they haven't for a long time. They're-
We do some, but then you use gated pipe instead of this, but we haven't made any statements about that, so,
Oh, I know, it's another issue.
but it is. Those things make good sense to me. Do you want to add something along those lines?
No, not today, but I think it's something that we probably need to talk about. It's, yes.
Okay. All right, I'd entertain a motion to support as revised.
I move we support the revised Deschutes Basin Habitat Conservation Plan comment letter as read today. It is actually dated November 13th, 2019.
I'll second it.
Okay. Thanks again, Peter, for being involved with this and going to the meetings and getting us more information, and particularly for setting. I thought the panel was really valuable for us to see more about it. So it seems like there's going to be more. We're going to deal with this in the future. I don't think it's just going to come to a quick resolution.
Well, and it's good that people are talking.
Yeah,
You know,
yeah.
I mean, we ask folks, there's differences of opinion here, there's the long history, so communication's the key to this whole operation.
Well, and what we're doing is saying we support taking this action, which is, I think is important. Because, otherwise we're definitely, even as it is, we're increasing, it's not the most aggressive proposal, but we'll be increasing the water in the river, so. Okay, let's see, who made the motion, you?
I did.
Okay, Commissioner Dare?
Yes.
Commissioner DeBonne?
Yes.
And Chair votes yes. So we gotta change that date, I guess.
I will send it to staff and,
Yeah.
signature.
We're gonna be meeting upstairs, so yeah, send it to Laura and we can sign it today if,
See you when I get back to my office.
Are we meeting upstairs now?
think so. We've got an executive session, don't we?
Litigation matter.
Litigation matter. So any other items for? So let's see, are we gonna recess then?
We'll just reconvene in what, 10 minutes upstairs?
Okay, yeah, we're gonna recess now and reconvene at, I guess 10 minutes, 4:55. 3:55.
3:55 upstairs for
Upstairs
executive session.
for executive session.